There is. Need to mention one item for listing on 3rd of August, non-payment of salary.
3rd August.
Finally, it in the month of November 2025. After additions of this matter has not been listed yet, my lord. So the matter will listed on 29th July for order.
Let it be in August. 10th of August.
Then,
Any date earlier?
I'll
5th of August.
Lordship, I beg to mention item 49. Item number 49, Lordship. Item 48 is wrongly tagged.
Huh?
So item 49 is wrongly tagged with item number 48. The issue in both the replays are different. But we have yet to file our affidavit.
Mention it when it comes.
Lots.
Mention it when it comes. You want to file your affidavit?
Yes, sir. Item 49. There are two other matters also there.
So you let the matter be not called up.
Yes, yes. Yes, please, Lordship. I would like to mention item number 11, my lord.
11.
Yeah. Item for a payment.
Item 11 on the request of the counsel for petitioner.
Yes, ma'am.
Matter stands deferred to be listed after 2 weeks.
May I please the Lordship? Lordship, with the consent of the other side, I beg to mention item number 20 and 21, Lordship.
Yes.
Lordship, conducting counsel Mr. S.S. Roy is out of station, Lordship. Kindly adjourn for the day, Lordship.
2021 on the request made on behalf of the counsel for the relief petitioner stands deferred to be listed after.
May I please the Lordship? So I beg to mention for listing a matter for withdrawal.
Withdrawals tomorrow.
May I please, Lordship? Lordship, I beg to mention item number 56. Please pass over the matter for today, Lordship.
56.
Yes, Lordship.
You submitted that you are for the petitioner.
Yes, Lordship.
On the request of the counsel for the petitioner, item 56 stands deferred, listed after 1.
May please, Lordship. I would like to mention for listing of an arbitration petition for 12th of August.
Why so specific? 12th of August.
In this matter, senior counsel Mr. Bidata is appearing. So be here personally.
All right, 12th of August.
Deeply obliged.
for listing on any day. Admission matter on any day.
Admission matter.
Yellow.
12th August.
May I beg to mention today is item number 14.
1-4.
Yes. Subsequently, we will consent to the other side and we want to file a reply. Only file a reply.
Item 14 on the request of the counsel for the petition stands deferred to be listed after 3 weeks. Directly him to file a reply. Rejoinder affidavit. The affidavit filed with the petition.
We pray for listing of these two items on 28th, Your Lordship, because similar matters has been disposed of by Supreme Court, Honorable Supreme Court, which are pending before the Supreme Court.
29th.
So I've been asked by the Mr. Senior Counsel to make a request if it's possible on 28th. If it is possible.
28th.
Yes. I'm deeply obliged, Your Lordship.
Lordship, item number 54, Lordship. We have recently received the affidavit in opposition, Lordship. We may allow 3 weeks time to file a 54, Lordship.
54. You want to file rejoinder?
Yes, reply.
Item 54 on the request made on behalf of the counsel petitioner stands deferred. Listed after 3 weeks and we will to file rejoinder affidavit. Yes.
From paying for listing of one contempt matter. It was last listed on 3rd of June. It was supposed to be listed on after 2 weeks. Hasn't been listed yet. Pertains to the alia of teachers.
3rd August.
Uh,
3rd August.
a bit sooner than that.
No, it's 3rd August is good. We are already on 22nd. So after 1 week.
Wait, please, the Lordship. Lordship, I beg to mention item number 32, with the consent 32.
32.
With the consent of the petitioner, madam. This matter may come after 3 weeks.
Yes.
No. C is not for the petitioner, madam. I have taken consent.
Item 32 on the request made on behalf of the Standing Council Elementary Education stands deferred to be listed after this. The submitted consent of the council for the petitioner has been obtained.
I pray for date, madam.
19th August.
For listing, for admission.
Admission matter. 12th August.
And the same prayer in the admission matter.
12th. August.
My lord, I did not mention listing of an IA matter, which was however listed yesterday before you, which could deferred matter. The filed against the yesterday.
31, 31st of July.
No, my agency, yeah, my
What
lord.
agency?
My lord, this court, my lord, has granted interim order against shifting of a school, my lord. School is going to open. Stay shifting of school, my lord. Stay was granted, my lord. We filed this IA to take the stay order.
So it can't be vacated on the same day,
My lord, tomorrow or Monday, my lord.
Monday.
Okay.
Take for list of admission, two admission matters. One was listed yesterday and last got deferred.
12th of August.
Obliged.
Yeah, please. I'm petitioner in person because yesterday my case was listed on the serial number 24. Their part had matter. The urgency as well as public.
We'll list it on the miscellaneous day and then we'll fix a date. Let it be listed on 3rd of August. Sorry, 5th of August. Then we'll fix a date. We will have to understand how much time we'll require, how much time the respondents will require. Accordingly, we'll have to fix a date for hearing.
Right, urgent.
Therefore, we are listing it on 5th. 5th of August.
Therefore, listing of rates to areas.
Areas and 12th August.
But in this case, I on behalf of Can Vision is like to suppose to file an additional affidavit that is to be filed today itself. That may be
It will be filed on.
today itself.
Submission is made on behalf of the counsel to the petitioner that an additional affidavit permitted to be filed. Filed in the course of the day. Counsel therefore submits that the matter be posted on some other date. Release this matter again on 29th. Mr. Vora appeals for the secondary elementary. Yes. Where is the clause?
Clause for arbitration.
Yes.
Page number 1.
Where is your notice?
1. Page number 313.
There has been for different contracts. We're not going to look at page
We
313.
will issue notice, you file your response.
All
Third.
the contracts, different contracts, one arbitration 11 is fine.
Which you file your objections. But cancel all the parties. Issue notice. General 4 weeks, Mr. H. Gupta, Learned CDC appears to respondent, all the respondents, therefore notices of the extra purpose will furnished with a period of 1 week.
The order violated, but this order is placed 44 lawsuit,
44.
44 lawsuit. And 11 person placed 49. Paragraph 6 lawsuit. Main violation lawsuit within 3 months. Can we see lawsuit last 3 lines lawsuit?
Third counsel for parties issue notice returning 4 weeks. steps on the respondent by speed post within 1 week. Matter be listed after the returnable date.
I pay for some more than 1 week time notice because they is under progress. We are coming for the record from the college also.
Huh?
We are calling some records from the college also. That's it. Just now I have received the instruction. As per instruction, that's 1 week time maybe that's it.
Yes, Mr. Nath.
I have just
Mr.
talked
M. Nath, Indian Council, assisted by Mr. A.
DJ Kapil.
DJ Kapil. And Mr. A. R. Tobildar, Assistant Council, Higher Education. Mr. Tobildar renews his prayer for further time. He prays for how much time?
1 week.
1 week's time. To furnish the information as directed by the sport by the order. Dated 25/6/26. Prayer made is not objected to by the council with petition. Relist.
Fourth point.
Fourth,
Third, yes, fourth. So he'll get little extra time he gets.
4 or
3/4 is extra time he gets.
fifth,
Yes.
Yes.
fifth of,
Yes, sir.
5th of August.
Obliged.
Apply.
Order 26.
Madam, in this case, on the last petition, we are directed to take instruction, madam, instruction not received, may pay notice may go, madam. Because his petitioner husband was died on in the year 1975, madam. And records could have come from the district also.
The notice should go. Let them file their response. Heard. Council for parties should notice written in 4 weeks. Mr. S. Sharma appears for the petition. Is
1,
set
3 and
here.
4, I will take.
Appears for respondents.
1, 3 and 4.
1, 3,
3 and 4.
1, 3 and 4.
I take notice.
MS S. Sharma for respondent number 2
And 5.
And 5.
and 5. If the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week.
This will be taken up along with item number 46 and 47.
46, 47.
May kindly be taken up at 2 o'clock. I have not received the instruction.
2 p.m. 2 p.m.
This is the third round of litigation.
Hmm?
Third round of litigation process. In this case, we have challenged the speaking order dated 9/5/2025 as well as the communication order 13/3/2026, whereby the claim of the petitioner for approval of his appointment as a lecturer of Mazali in Assamese department has been rejected. This honorable court already directed the respondents to verify the claim because in the meantime, the petitioner appeared in a selection process, but he did not have the requisite qualification. Subsequently, he got the MPhil degree. So therefore, this honorable court has directed them to verify the claim. But subsequently, on 9/5/2026-25, by way of the speaking order, that claim has been rejected. That's why we oppose this honorable court.
Where is the impugned order?
Impugned order is 70. Yes,
70.
70. The second round of litigation is the order passed on 18/1/2024. Start from page 62. Particular page 68, paragraph 18, 16.
Heard. Still key Kulita. Mr. Ria Govinda for the higher education.
That's 1, 2, and 3.
Representing respondents 1, 2, and 3. And Ms. P. Agarwal for
On number 5.
respondent number 5. This is on behalf of respondent 1, 2, 3, 5. Stands waived. However, extra copies we furnished. Steps on respondent number 4 and 5, 6. The undertaking, speed post within 1 week. Relist this matter again after.
Hello. Hello.
No matter. Yes. Pull up again. Pull up.
Your Lordship, the petitioner is a final year student of IIT Gauhati, and by the way of the present petition, he is challenging only penalty number 1 of the disciplinary sanction of IIT Gauhati, that is Annexure P1 at page number 31, in which, Your Lordship, the petitioner was suspended from attending the upcoming semester of July to November. Your Lordship, the allegation against the petitioner is that on the night of 26th March 2026, petitioner along with 5 other students have verbally abused the first year student in the hostel. Subsequently, Your Lordship, the matter was referred to the anti-ragging committee, and subsequently, Your Lordship, on 22nd of April, an FIR was registered against the petitioner. An FIR is at Annexure P2.
Let them obtain instructions. You obtain your instructions.
We have got
The instructions are available.
that anti-ragging committee report is there. It shows this is a clear case of admission, and even that audio records are there, and that sort of audio visual records are also there. It's been all placed before the committee. It shows that
Can it not be brought on record?
it can be brought on record.
You bring it on record.
Yeah, we'll bring it on record.
You bring it on record.
Your Lordship, my
No, but interim will be dangerous because this small boy, school pass out kid, is under mental trauma now.
Your Lordship,
Parents are worried for that. It's unless some lesson is given to these boys, this is meanness.
Your Lordship, this penalty has been imposed only on 2 students out of 6. Furthermore,
We'll examine it. Let the report
let
be
it be, Your
brought on
Lordship,
record.
but my request is that, Your Lordship, I'm not an habitual offender, neither have committed any heinous crime. An FIR has already been registered against me. Your Lordship, I'm a final year student, and my request is that my whole career will be spoiled if and placement is right in front of me, Your Lordship. So till the pending of the petition, I stay may be granted, Your Lordship, an interim relief to attend the classes, Your Lordship. All my request is that. We are the
Lordship,
few.
we'll take up the interim matter after we produce all these things.
How long will you take?
In a week, Lordship. Collect all these things, understand and place it.
10 days.
Your Lordship, meanwhile, because semester
Do
has
it
been
on
started.
29th?
Lordship,
29th?
Lordship.
29th will reconsider your prayer for entry.
My request is that, Your Lordship, that I'm appearing from Delhi. So an interim relief may be given, Your Lordship, till then to attend the classes at least. We have
For
already,
these
Lordship,
days classes,
we have-
for small days, you not.
Without examining these matters, ordinarily we'd issue a notice.
Your Lordship, we admit that we have verbally abused,
Then-
but there is no physical assault, no physical violence is there.
Whatever it may
And
be.
on the basis of that, only FIR has been registered against us. We admit that, Your Lordship. But penalty number 1
We'll
is
have to
very
see,
grave in nature, Your
Mr.
Lordship.
Council will have to see what the rules and regulations lay down for taking recourse to such issues relating to ragging.
Yes, Lordship.
It's
My
a serious offense.
My request is that we are ready for all the penalties, Your Lordship,
Ah,
that has been imposed on me, except penalty number 1. Because suspension of the semester is very harmful for my future, for my career.
that's what we'll examine it. We'll examine it
And
later.
that penalty has been given to only 2 students. It's a clear violation of Article 14 and 21.
Where is the question of Article 1421? You admit that you have committed.
Your Lordship, but all the 6 students have committed. So
Different
why only
charge,
to the 2
different
students?
Lordship.
All right, we'll direct them to issue the penalty on all the 6 students. That is satisfying.
That will not satisfy us. We are
Then-
students, Your Lordship.
Then-
Having a bright future, we are the future of the country.
No, future of the country is quite all right, but the people in whom the future
At the
is
same
vested
time, Your Lordship,
must
this-
also have the responsibility to act responsibly.
But Lordship, parallel proceedings cannot be allowed.
What is the parallel
FIR
proceeding here?
FIR has already been registered.
All
That
right,
is a
then we'll
criminal
issue
proceeding.
notice, let them file it. Heard counsel for party issue notice.
Your Lordship, till then a stay may be given to attend the classes.
No,
An ex parte
returnable.
relief.
Returnable on 29th. for July. The respondents may complete their instructions and file necessary affidavit. Issue all notice on the interim prayer. We listed a returnable again on 29.
The petitioner is an employee under the NCM's Autonomous Council, Lordship. Kindly peruse the page 31, Lordship, of the writ petition, Lordship.
31.
Can I go through it, Lordship?
Yeah.
Order, whereas the undersigned has received the following letter so and so, wherein it is stated that the service of Srimati Juhi Huzai, grade for office of the PM City Government Girls Higher Secondary School, Haflong, is no longer required by the authority of North Castor Hills Autonomous Council, Haflong. Accordingly, she is released from the disposal of North Castor Hills Autonomous Council, Haflong, for her posting elsewhere, and the undersigned had been directed to take action in this regard. Now, therefore, Srimati Juhi Huzai, grade 4 office of the PM City Government Girls Higher Secondary School, Haflong, is hereby informed by the end of the said decision taken by the authority of North Castor Hills Autonomous Council, Haflong. This order comes into force with immediate effect, Lordship.
No, this is for what? Posting.
No, Lordship, they have released my service from NCL's Autonomous Council, Lordship. Now, kindly peruse the order of appointment, Lordship.
Why is this order issued? Is it termination or transfer or what?
Nothing specific, Lordship. Only on basis of 2 orders, this order has been released, Lordship.
No, it says she's released from disposal of North Kachar Hills, so and so, for her posting elsewhere.
Lordship.
So where are you posted?
Nothing, Lordship. Till that, no posting has been made, Lordship.
Where is your appointment order?
Lordship, kindly peruse page 18 annexure A, Lordship. And appointment order is at page 20, Lordship. Can I go through it, Lordship?
Yes.
Order, in pursuance of the Inspector of Schools, Dimahasa, Haflong, by memo number dated 15 February 2020, Srimati Juhi Huzai is hereby allowed to join as grade 4 in the Government Girls Higher Secondary School today, the 20th February 2020, in the scale of pay so and so plus grade pay of rupees 39,000 as per ROP 2016 and other allowances as admissible against the vacancy of Sri Viren Singh Longmalai, grade 4, retired, promoted to junior assistant, Lordship. Without showing any reasons, Lordship, only on the basis of 2 letters, Lordship, she has been removed from service, Lordship, under the respondent authorities, Lordship. They
Yes.
are regular.
Lordship, I am appealing for the respondents. Here, Lordship, although it says she's released from disposal of North Kachar Hills Autonomous Council, however, it also says for her posting elsewhere. Lordship, I'll bring instruction on this aspect, Lordship.
When can you get it?
Lordship, a similar matter is also fixed on 5/8/2026, Lordship.
5/8.
Lordship.
Lordship.
In that particular case, Lordship, stay was granted. I have the order.
No, is it, we just need to know whether it is termination or
Yes,
change
Lordship.
of posting.
Lordship, I'll bring instructions on that, Lordship.
If you want it on 5/8, then we'll have to issue some interim orders, or have it on immediately 27, you can have it.
Lordship, in that case, let it be fixed on 27.
On
Lordship,
27.
I'll bring it.
Let
Lordship,
this
Indian
matter be
Lordship.
relisted again on 27. On which date? The standing council for which department?
Lordship, for NC Hills, Lordship.
NC Hills. Will
Lordship,
obtain required
Lordship, can I
instructions in
submit,
the
Lordship?
matter.
If another order is passed, Lordship, then my repetition would become infactual.
What order?
Lordship, if a transfer order is passed, Lordship, my repetition would become
Where is the grievance that you will continue to work in NC Hills and not be transferred out anywhere else? If there is some order, you put it to challenge. You are in the government service.
Lordship.
So somebody has released you. Now the only question is whether you are released pursuant to any order of termination, or is it in place of, for orders issued for transfer and posting.
But they are,
Prima facie, the order appears that you are to be posted elsewhere. Now, where are you posted and which pastest order is not available?
Lordship, kindly peruse one order of the respondent authority, Lordship. Lordship. I am going to show the conduct, Lordship. Kindly
We are asking you a specific question, give us a specific reply if you have, or let them get the instructions. We are giving you the shortest date possible.
till then,
We are not rejecting your interim prayer. We'll reconsider on 27.
till then, Lordship.
Not till then. Till 20, on 27, we'll reconsider. Release this matter on 27, enabling the state, the council for the NC Hills to obtain required instructions with regard to the status of service of the writ petitioner pursuant to the order issued by, pursuant to the impugned order issued by, where is the impugned order?
Lordship, page 31, Lordship.
Issued by the principal in charge, PM3, Government Girls High School, Higher Secondary School, Haflong, whereby she was released from the school as a grade 4 officer, employee. List on 27.
Lordship, that observation may be made, Lordship.
The prayer for interim would be reconsidered on 27.
Oblige, Lordship.
Extra copies be furnished during the course of the day.
Lordship.
Yes.
Okay, here, SMDC, resolution was passed on 8/10/2025, whereby, a bidder, that is Oishwarya Haspal, was selected for awarding the contract of providing free uniform at Panchagram High School, Borpeta. But subsequently, that decision was tempered by the headmaster, and he had selected solely, that is Vishwas Enterprise. So this is the contention, and due to that friction, my lord, that scheme could not have been, my lord, implemented. I have approached the higher authorities, but no action has been taken in this case. Petitioner is the president of the SMDC.
Get instructions.
My lord.
Third council for parties. Council for the elementary,
Secondary education.
secondary education. Sharma will obtain required instructions. Matter. Release this matter again on 5th of August. Although notice is not issued, extra copies be furnished to enable the standing council to obtain required instruction. Name is Sharma, appears for respondent.
1, 2, and 5, Lordship.
You are for 1, 2, and 5?
Not 3.
Sharma for
Oblige.
None appears. The petitioner of the call. Second time. List on Friday. Or Monday, Friday. Mr. Air Tovildar appears for the higher education. appears for the parties in court. It is the matter next week.
And on the last occasion, the education department apprised the honorable court that the matter has been laid before the cabinet, my lord, for making appropriate.
Yes, who is for the
Provisions
respondent?
of-
Where is Mr. Chisti? Huh?
He's on leave, madam, for this. SMT. Next statement, anything.
Next day, my lord, let them apprise the court matter. What is the outcome of the placing matter?
What is to be placed? The draft rule.
Draft rules
Draft rule regarding?
regarding, my lord, promotion of the grade 4 employee of education, school and department. My lord.
Great.
That rule, it's called, my lord, Assam. Rule of 2003, my lord.
Mr. J. Borghi. As I said here, counsel appearing on behalf of Mr. SMT Chisti submits that Mr. Chisti will be therefore.
Known as, my lord, Assam Secondary Education Provincialization of
It is
School Service.
submitted.
My lord, I have received the instruction. my lord. Finish.
Submitted. Instructions.
Copy the news.
So it is approved.
My lord.
You show it to him.
My already.
And let it come, my lord, I need an extra lord.
Where?
Because just now I've seen, my lord, I have not seen.
What is there to be seen? There is a direction to apply.
My lord, whether it has been complied or not, my lord, just.
That we can check out just now from the order for non-compliance of which you have filed the contents.
My lord. operative part of order, Lordship will see at page page 58, my lord,
P8.
my lord. 58.
So you are filing this contempt for non-compliance of which order?
This particular order, my lord, which has been affirmed by the division bench, my lord. Particularly page 34, my. There are 29. After hearing the learned counsel for the parties considering the intent matter instruct the respondent authorities in secondary education to directed to do needful with the provision of Assam Secondary Education Provincialization Service Rule 2018 so that to comply the direction of the division bench in common judgment order dated so and so passed in so and so. Taking such provision, this is the specific direction. So the promotional secondary state of the juniors in such schools are directed by the new common judgment passed in other connected cases. Order so and so is hereby set. Page 34. It is treated from page 58.
Submitted by NSCTL that the matter has been placed before the cabinet. Cabinet has already accepted the proposal. Relevant communications are placed before the court. However, considering copy of the same is shared, is also supplied to the counsel petitioner. Mr. Bormani submits, so the matter will be posted next week, enabling him to peruse the same, enabling him to complete the instructions on this. Released on 31st of July.
Lordship, in this matter, we had filed our affidavit on 24th of June. But because of some difficulty, my lord, that it's not defect, my lord. I have to correct that defect
Next week.
I have to fix it on the next week, my lord. Otherwise, my lord, it is in the process of compliance, my lord. But there's one issue there, my lord. The university where her name was, my lord, her name was wrongly reflected in the sense of there was a error in the name.
You bring your affidavit. First, you correct the defects, bring it on
I'll-
record.
fine.
Mr. N. Sharma, petitioner, Mr. A. Bhuban, for the respondent, Mr. Bhuban submits that the affidavit of the file has not been accepted by the registry because of some defects. He submits that he take all steps to clear the defects and raise before the court that the matter be listed after a week. Release this matter again after a week. Accordingly, release this matter again after a week, by which date the respondents will ensure that the affidavit filed on behalf of the respondents is cleared of the defects.
That may be.
7th August.
Deeply.
Lordship, as per order dated 3/26, Lordship, the petitioner had accused the respondent authority, Lordship. However, till date, he has not taken any step.
Your Lordship, we have got instruction from IS Naga, Your Lordship, Inspector Office. We'd like to file our affidavit on this regard.
Director of Pension has also written certain deficiencies in the proposal are being asked for from the school, the inspector school.
Bring it on record.
I will.
SP Sharma, MSP pass appears for the, which respondents?
I'm appearing for respondent 1, 2, then 4, Your Lordship.
Respondent 1, 2, and 4.
I appear for 3 minutes.
Submits that instructions have been received. She would like to bring it on record.
Treasury.
MSS Sharma appears to respond.
3 and 5 minutes.
3 and 5. Release this matter again after 2 weeks.
Lordship, kindly a date.
14th August.
Much obliged.
Later, Your Lordship. Later, Your Lordship, or before Your Lordship, not 14th, Your Lordship. Open prayer is there, Your Lordship.
19th August.
I'm deeply
Much
obliged. Instruction. Try and bring this matter में pass over the date because SMB 50 is not out of season.
Only date maybe.
Mr. A. Salim appears on the petition. MSS Setia appears on behalf of Mr. SMD Chisti and submits that Mr. Chisti being not available today in court, matter be passed over the day. The prayers made. Release this matter again on 29th.
Obliged.
of
Deeply
July.
obliged.
You're appearing?
Yes, Lordship, and Lordship, we could take the matter for the time.
Next week. Next week.
Can my matter accept any other date on 29? On 29, I will not.
31st.
31st. Deeply obliged.
Yes.
But the issue is, my lord, that the petitioner has not been given the charge of the principal because he has crossed the 57 years of age, man. And similar case, the lordship. Presently, he is holding the academic charge come vice principal of the school. But he doesn't open the financial charge, my lord, as because he has crossed the age of 57 years.
Your Lordship, here private respondent number 4 is still there, Your Lordship, and copy needed to serve upon them also, Your
You
Lordship.
have taken steps, my lord, he has not done.
Service is complete on
Service
respondent
is
4.
complete, my lord.
Service com-
What is this?
This is the, my lord, proposal forwarded by the DSC Assam to the government, my lord, for considering the relaxation of the age of 57 years. This is for direct recruitment, it is for in charge.
What has happened now?
Now I'm holding the academic charge come vice principal of this regular vice principal of the school, but I have not given the charge of the financial charge.
Your
Because
lordship,
I have
instruction
brought the-
awaited your lordship, some time may be granted
I
to
have
us, your lordship.
57 years. That is down.
7 years, I need some 2 weeks, your lordship, time completion, your lordship.
Already there is a proposal from the director. Ma'am. My humble submission is the matter with remanded to the secretary, my lord, for consideration of the age relaxation.
You're praying for a similar order.
Similar order, the similar facts is different, my lord.
Your lordship, let the instruction may obtain your lordship. Then your lordship on the next day take me.
Your instructions are that there is a proposal already submitted.
Submitted.
And the minister also held some meeting and directed the director to look into the matter. So what has happened now?
For that, your lordship, up to date instruction, your lordship, I need some time, your lordship.
How much time?
2 weeks time may be granted to us, your lordship.
On 29th, my lord, another similar matter is fixed.
It will come after 2 weeks.
The date may be
As prayed for by the state council, seeking further time to complete the instruction. Released on 10th. Yes,
19, your lordship.
19th. And let us have it on 12th.
Yes,
12th
your
August.
lordship.
Challenge the appointment of respondent number 8, who has not 15 member saying that he belongs to HTH Ken. So ultimately the matter was inquired, report has been given, it is found that the respondent number 8 is then HTH Ken. So depriving the petitioner from being the post. So last order was there 15/5/26 in IA 1502/2026. Your lordship got it. So director higher education is there to take action on the matter.
Yes, higher education.
Requisition may be directed to be disposed of within a specific time, then I think the purpose will be served.
There is a, your lordship will kindly see that the order is there that the appointment of respondent number 8, page 18, 19 matter of that IA. That petitioners, your lordship disposes of them, there will be a contempt,
Then,
because they will not follow up anything.
then some
There is an order, that
10
order
days
should
time,
be
then
followed.
lordship.
Where is that order?
Page 19, my lord. That interim order is there.
19 of the IA.
IA. That is the order dated 12/6/24. It says, my lord, the appointment of respondent number 8 will be subject to the outcome of the writ petition. So ultimately, my lord, the inquiry was held and the report has been given, and the report shows that the respondent number 8 belongs to HTH Kin. So he could not have filled up the post because the advertisement was for STP candidate. So they should take instructions
Yes,
and get the
yes.
matter disposed of. Let
Yes,
them
lordship,
take
I can-
another day.
that can.
What he can provide in another week time.
Yes.
So if the matter is disposed of, my lord, another content.
Lordship, senior is saying.
The BD plus senior counsel assisted to is for the institution. Again. There, it is for the higher education department. Or for tribal affair. Tribal affair.
Right.
MS Sharma for 4. Mr. P. Adoriga for respondent. 7. The higher education department is permitted for the time it is requested to complete instructions as to the status of the claim of the writ petitioner. Writ petitioner for being appointed to the post of
Grade 4.
grade 4, reserved for STP.
STP.
In view of the
Report is at page 54 of the report.
report received by 4 of the writ petitioner.
Yeah.
View of the report of the state level scrutiny committee on the complaint of the writ petitioner and the finding that the private respondent number 8 does not belong to STP community of Assam, rather they belong to STH.
Yes.
So it is the submission of the Learned Senior Council that in view of this categorical report dated 21/1/2026, the post available for STP should be filled up, should be made available for appointment of the writ petitioner as it belongs to the STP category. However, no steps have been taken by the respondents. Whether Mr. Tovildar submits that he would like to complete instructions in this regard, he waits for 2 weeks further time. Release this matter again on 14th of August.
Okay, can it be?
You are saying on 7th.
7th, all right, 7th
Because
August,
if I may not get done, it will be 14 or maybe on 12th, only,
12th,
not on 14.
12th August.
All right. All right. Thank you very much. Well, item 25, the final IA for implement in WPC 5814/2025 as respondent number 5. Happened, Your Lordship, the petitioner in 5814/2025 and the applicant herein both are teaching in the same school. And the applicant herein is claiming to be the senior most teacher in that school, and she claims to be the for the post of headmistress of that school. Now, the petitioner in 5814 had assailed an order by which she was directed to join her original place of posting, but that order has been stayed by this honorable court, and she has not made me a party. Although I have also filed a writ petition, which is the item number 26. I have made her a party. That proceeding that she was not supposed to be the senior most teacher in that school, and she was holding the post of headmistress illegally. Although disciplinary proceeding and other proceedings are also being, inquiry reports are there, but this application has been filed for my imprisonment in her writ petition.
You are seeking imprisonment
Imprisonment here
as a respondent.
as a respondent number 5.
Notice issued here. Is there any
Yeah.
objection?
We have filed our affidavit in opposition in this. I am, my lord, stating that, my lord, so far the transfer order is concerned, my lord, there it is not the vice versa. The applicant is not affected by the impute transfer order at page 30. My lord,
30
there
of
30 of the affidavit, my affidavit in opposition, my lord, in the IA. My lord, by misunderstanding that my attachment was cancelled, I was directed to join my original post. But already, my lord, my service was confirmed, my lord, in 2007, page 29, in the school, and I am the senior most. My lord, in view of the, my lord, confirmation in service against the substance, it was at page 29, my lord. So this order was not taken into consider while issuing page 30 order. and therefore this honorable court has been pleased to stay this order of cancellation of attachment. So since this order is no way connected to the applicant, this is not vice versa transfer, my lord, and she has claimed seniority that another repetition already tagged. So both the repetition may be taken up together, my lord, matter may be finalized. Whether she is senior to me, or this can be at the, my lord, finally, this can be directed to the director to decide who is the senior. So in the present petition, wherein I have challenged the order at page 30, Impugn Order 29/2025, this order no way, my lord, affects the applicant. So therefore, I have raised objection, my lord, in view of my confirmation in service in 2007, which was not taken into consideration in the impugn order. So rightly, this honorable court has stated, and our application, writ petition, and my writ petition may be taken up together.
You have also filed a writ petition.
Yes, second one, page 26, item 26, my lord.
Item 26.
Yes.
26.
Claiming seniority, my lord.
You are not a party there.
I am.
You are a party.
Yes.
Then
My lord, therefore, my lord, both the writ petition is before this honorable court, my lord.
therefore she wants to be a party in your writ petition. Why are you objecting? If you want both the matters to be heard together.
My lord. And she has not been confirmed in services till now in the school. And
in your writ petition, what is your challenge?
My lord, I am claiming to be the senior most headmaster teacher in that school, and I have submitted
over her.
over her. And in fact, some inquiry is against inquiry report is there against the petitioner, page 69. That she joined service somewhere, she was posted somewhere else, and she joined in that school where her husband was the headmaster.
In the school in which you are working.
Yes.
No, at that point of time, she was not there.
At that time, but lot of people see page 69. It's a type copy, translated copy.
You are seeking enforcement of some order. 29/5/2018.
That
allowing me to,
yes, allowing her to hold the post of headmistress. Kindly see the paragraph 2. I just slowly. During the course of hearing, the
Which you're reading from?
page 69 of the petition 1469.
69.
This is the inquiry report. Second paragraph, during the course of hearing in presence of all the 4 members committee, Srimati so-and-so, headmistress number 2, that is the petitioner there, Gulimara Lower Primary School, stated that she was appointed by the order number so-and-so dated 13/10/1991 in Gojalbosti Lower Primary School and joined her service on 14/10/1991 in number 2 Gulimara Lower Primary School. As an assistant teacher, she cleared the basic training course in the year 2006 and serving as headmistress of the school, said school since 1/4/2018. In response to the complaints raised against her, she had stated that earlier headmaster of the state school is her husband and he regularly visited the school till date to help her in different school management works. So-and-so had submitted written statement before the inquiry committee with her appointment letter and qualification certificates along with office order whereby she has appointed as headmistress of the state school. Now the decision below, my lord, decision of the inquiry committee. Upon proper examination of the records as available and on the basis of the hearing given by both the parties before 4 members committee, the following decisions are hereby decided. It is natural to be displeasure of the complainant Srimati Archana Fugal, that is my in my case petitioner, not to appoint her as the head teacher despite being the senior most trained and graduate teacher in the school. It is proof that the husband of the present head teacher in the school, who is also the earlier head teacher of the said school, intervened in different school managing works even after retired from his service. That though Miss Srimati so was appointed as assistant teacher in Gojalbasti Lower Primary School on 13/10/1991, she joined as assistant teacher in the number 2 Golimara Lower Primary School, that is the school in question, on 14/10/1990. To that effect, no any office orders were available regarding that. The matter has become very suspicious since her husband Sri so-and-so was the then headmaster of the school. So by this inquiry report, it was decided that I am the senior most trained and graduate teacher in the school, and she was appointed somewhere else. But since her husband was there at that time, or the headmaster, she joined in that school. Now, page 75. This is the another show cause notice issued to the petitioner therein. She was directed to submit the joint.
What is the stand of the department here?
Before that, just one clarification. He has enclosed my subsequent order after 13/10/91. 14/10/91 he has enclosed. Page 43. There is an order since in the present school Gulimara number 2, page 43, 0 teacher. So therefore the petitioner was posted there, page 43. And pursuant to the later asking me to provide this appointment order, original page 44, I submitted before the authority. And after that, my lord, over and above, my lord, my service was confirmed as I have shown, my lord, under Rule 5 of the Secondary Education Service Rule, my lord, elementary education, my lord. In a substantive post, page, in the IA application that I shown, page 20, my lord, 9.
No, we are now trying to decide whether the necessary party.
Yeah, that's correct.
It appears that
My lord, because I am, my
the
lord,
issues are there. She's claiming
right.
she's
Seniority.
seeking a direction against you
Yes.
regarding your appointment as in charge headmaster, and you're questioning that you had joined this school.
Yes.
When you were required to join in others. And you are a party in her.
Yes,
in the writ petition file.
That's correct. Now only the ground is that, my lord, since claiming seniority, her writ petition is pending. This is another writ petition filed by me challenging my removal of attachment order. This order does not hamper him, and her seniority can be decided in the item number 26. So, in that view of the matter, she is not a necessary party in this writ petition. That's my submission. My lord, may record my submission.
Your writ petition is WPC?
Yes.
5814.
5814.
Correct.
And the order is stayed by this honorable.
Yes.
That order is affecting my.
Both the writ petition has already been taken together, my lord.
But this is third writ petition filed by the petition.
Earlier, the order was.
Which order is that?
Order, my lord.
Yes. Order, my lord, in
your writ petition?
My writ petition, in fact, the order I have annexed at the IA affidavit, my lord, page 31.
No, you have filed the writ
Page
petition.
47. Correct. Page 47.
You are challenging which order?
Yes.
Annexed
47.
Yes.
All right.
So you are sent back to Gojalbasti.
Yes.
But
Because
this order is stayed.
because already my service was confirmed in number 2 Gulimura
Therefore, she is affected.
by order of 2007, my lord.
If you are transferred back, then
Yes.
she comes into your place.
My lord,
If this order,
yes,
if this order is allowed to be implemented,
implemented.
you come back to she assumes your position.
That my submission is that she is continuing in the present school on the basis of attachment. That order he has enclosed. Her appointment is on attachment. Mine is not. So in view of the order of the department, her attachment should be cancelled.
But is that a prayer in your petition?
I have not read that. My lord,
Well, let us hear the state.
yes.
No, what do you say? Petitioner is the senior most. Petitioner in the IA. Now, this status of attachment is not an issue before the court.
My lord,
Somebody has to raise this issue.
so far my lord, they have not all along considered my lord confirmation order. In the school, my lord.
Right. Heard. Mr. In WPC number
1269.
one. IA 1602.
Yes.
Mr. A. Dhor appears for the applicant who is the petitioner in WPC 1469 of 24 by the said writ petition in 1469. Petitioner is seeking a direction for setting aside the order dated 29/5/2018. What are these orders you are challenging?
My lord. Page 40.
No, Mr. Dhor.
Sorry.
Yes, ma'am.
What are these orders you are
Yes,
putting
by
to
this
challenge?
order, the petitioner was asked to remain in as an head teacher.
So, but why are you challenging it?
Because there are some pending inquiry allegations are there, some inquiry reports are there. She is not entitled to all this with this.
So these, where are these orders?
Yes.
Page number 32. Your prayer, you have sought for a setting aside of these orders. Where are they?
Yes. Page 58. And 57 is the translated copy.
Seeking a direction to interfere with the orders whereby the petitioner has been asked to function as the head teacher temporarily. Stop it is the grievance of the petitioner that she is the senior most teacher in the Limara Lower Primary School, in the district of Dibrugarh. Stop. However, the private respondent number 5 has been number 6 is permitted to operate as head teacher, for which these orders have been put to challenge in the writ petition. Stop. It is the claim of the petitioner that she is the senior most, therefore it is her claim to be considered for appointment as head teacher or headmaster of the so-and-so school instead of the private respondent 6. So there are the WPC 5814 is filed by Srimati Mamta Ghosh, who is the private respondent in WPC 1469, whereby the said petitioner has received the order dated 2024, case 47. 2009, whereby the attachment order of the petitioner is cancelled. Dated 29/5/2003 was cancelled. Attachment order of the petitioner in the Gulimara LP school has been cancelled, and she was directed to join in the original place of posting, which is Gojal Bosti LP school. Stop. While issuing notice, this court has granted an interim order, staying the interim order. The petitioner in WPC 1469 therefore has filed IA number 1602 seeking impleadment as a party respondent in WPC 5814. So, the learned counsel appearing to the applicant in IA number 1602 of 26, who is the petitioner in WPC 1469 of 22, submits that her claim in a writ petition for WPC 1469 of 24 is that she should be permitted to be appointed as the head teacher in place of the private respondent number 6 therein, the petitioner in WPC 5814 of 25. However, that has not been done. Therefore, the writ petition 1469 of 24 has been filed by the said writ petition. Stop. Insofar as WPC 5814 is concerned, 5814 of 25 is concerned, the said writ petitioner was released from her attachment in Gulimara LP school and directed to join in Gojal Bosti LP school, which was her original posting. However, by order dated order dated 26/9/2025, this order came to be stayed by this court by issuing notice. Therefore, the petitioner has filed the IA seeking impleadment WPC 5814 of 25, ventilating her grievance that because of the interim order granted, the order issued by the respondents cancelling the attachment of the writ petitioner in WPC 5814 was stayed, and that has adversely affected the claim of the writ petitioner, the applicant, in permitting her to charge, permitting her to be appointed, considered for appointment, so head teacher in Gulimara LP school. So it is submitted that petitioner, being an affected party, it's necessary to be impleaded in WPC number 5814/25 as party respondent, as her claim for being appointed as head teacher in Gulimara LP school has been not been fructified due on the order dated so and so, passed by this court in WPC 5814 of 25, suspending the order of cancellation of the attachment order issued to petitioner. Therefore, submitted. It is submitted that this order was passed ex parte. The applicant, therefore, she is a necessary party, and 6 orders from the court for being pleaded as a party respondent in 5814 of 2025. Also submitted. The writ petitioner in WPC 5814 of 25 is already a party respondent number 6, WPC 1469 of 22. Where having heard counsel for the parties, the MSSCT and his body state does not dispute the position on facts. Where having heard counsel for the parties, spoken to the considered view that as a necessary corollary to the order dated when 2009-2025 issued by the Director Elementary Education, whereby the attachment order of the petitioner in WPC 5814/25 stood cancelled, and she was directed to join in her original place of posting, which is Gauhati LP School, which was issued earlier by the order dated 13/10/1991. The applicant claims to be the senior-most teacher in Gauhati in Limara LP School. Oma would naturally be the candidate to be chosen for post of head teacher or headmaster as per the rules. So, if that be so, then and also considering the fact that the claim of the petitioner vis-a-vis present claim of the applicant vis-a-vis the present petitioner is also an issue in WPC 1469 of 2024. This court is of the considered that the applicant should be added in party respondent in WPC number 5814 of 2025 for so that effective orders can be passed in these proceedings. So the IA number so and so therefore stands allowed. Srimati so and so directed to be added as a party respondent number 5 WPC number 5814 of 2025. The writ petitioner in WPC number 5814 of 2025 will file amended post title in view of the order passed to the IA number so and so. So the amended post title will file within a period of 1 week from today before the registry. I accordingly stands disposed in WPC 5814, right, in view of the order passed today in 1602, IA 1602 of 25. Srimati so and so, the applicant in the IA is added as a party respondent number so and so. The petitioner will file amended course title within a period of 1 week. That will be posted immediately thereafter.
Obliged. He has to file affidavit.
After 1 week,
Obliged. The interim order will be continued.
interim order
By
passed in WPC. No, that will not say. Because is there any direction that it is only too late?
Yes, on last occasion it was 1 or 2 days late.
The last order, it was not extended.
They took time.
22/5/26.
Only they took time in the mention order. And before that, the extension order is there.
Interim order passed earlier, stands extended in next returnable date. They have to fix a date. 7th of August.
Yes. But it will be
Or
after 8th of August, madam.
21st of August.
Obliged.
21st of August. The extension of interim order will not prejudice the claim of the newly implemented respondent.
Obliged.
My lord, the name of the SNO 3, my lord. SNO 3 is not in the dispute, my lord, and in paragraph 5 of the petition, if you'll also see, paragraph 5 of the petition, page 6, their petition. That's number 3, MP Agarwala Private Limited was an original party of the MU, but ceased to be an active participant thereafter and had been arrayed herein as a proper respondent, but they have been as main victim. And being a significant, no substantive relief, not against the principle. In the section 9 petition also, I was not a party man. The dispute between the.
Lordship will file reply, 1 week time maybe.
You file?
One will reply, will file the reply to the
Reply.
application in this case.
They
Because
themselves say, my lord, that
certain
they
consequences
have
have been taken place that needs to be brought in the court.
You want to file a reply?
Reply. 1 week time.
Heard Mr. Saiwala, senior counsel, assisted by MS.
P.
And Mr.
K.
KL Gupta, appearing for the department, the petitioner. The Mr. Saiwala submits his I has been filed seeking removal, deletion of the name.
Yes.
Of the applicant, please so and so, from the array of respondents as the present applicant does not have any claim. As there is no claim vis-a-vis the applicant and the petitioner in arbitration petition number so and so. And therefore, the IA has been filed. Issue notice, returnable 2 weeks. Mr. Gupta represents all the opposite party. The petitioner, Mr. Gupta, submits that he would like to file an objection. So, since since the parties are represented, notice of the waived, extra copies furnished within a period of 3 working days. Released after the returnable date.
Lordship, in this matter, I have not received any instruction. I paid for 2 weeks of time, Lordship.
Lordship, this there is very simple. Peruse the page number 80. Yes, page 18. In fact, the complaint was lodged that the school operating without any valid permission from the authority. My daughter, without knowing the fact, got admission in this school. The fee they had collected was not deposited. Accordingly, she could not appear in the exam. This was the allegation raised by the father of the student who is the petitioner. Accordingly, a proceeding was started by this notification, which is the page 18 in exemption. Date was fixed for hearing, but on that day, I remained present and the other side remained absent. Thereafter, the IS who issued the notice, he did not conclude the proceeding. So my prayer is very simple. I am praying a direction to the IS to conclude the proceeding in terms of the page number 18. And Lordship, it is very clear that once the proceeding is started, it must come to a logical conclusion.
Then let them get the instructions first to find out what is the status. What is the status?
Of the page number 18.
Pursuant to page number 18.
Lordship. Short date maybe, because it's a very simple matter.
Mr. F.Z. Mazumdar was the petitioner, MS N. Sharma.
N.M. Sharma.
N.M. Sharma appears for the
Respondent number 1 and 2.
1 and 2. Relist this matter again. On 14th August, enabling her to complete her instructions.
Please, Your Lordship. Lordship, in these matters, the respondents have still not filed any affidavit, Your Lordship. And similar matters were there before court number 19 today, Your Lordship. And that those matters have been ordered to be fixed on 28 April.
The respondents are permitted 3 weeks further time to complete their instructions and file necessary affidavit. Mr.
T. Kashyap.
D. Kashyap.
T. Kashyap.
T. Kashyap appears for the request. Released after 3 weeks.
Lordship, on 28 same matters have been fixed and ordered to be tagged along with this.
We can't order that. If the matters are fixed by some other court, will come before that court, may come before this court. But can we say matters before that court be connected to this matter and listed before this court?
No, no.
Or listed before the other court? We can't.
So if I may, those matters have been listed to be listed along with this matter, but a date was fixed, which is 28 April.
You did not point out before the court that this matter was listed today, before
Lordship,
this court.
That has been pointed out.
You show us that order.
Not uploaded. However, if Your Lordship says 3 weeks.
Matters, there are 2 sets of matters listed before 2 different courts on the same day. How can there be an order to say that these matters in one court be listed along with the other court without knowing what orders are going to be passed by the other court? Produce a copy of that order. We'll see.
Much more.
Here, on last occasion, my friend asked for his applicant to file affidavit. It is prepared. By tomorrow, we'll file it.
By tomorrow. Mr. B. Chakraborty for the petitioner, Mr. P.K. Bora appears for the elementary education. He submits that the affidavit will be filed within 1 day. By tomorrow. Therefore, considering the submissions made, release this matter again after 3 weeks, enabling the petitioner also to file rejoinder affidavit to the proposed affidavit stated to be filed, proposed to be filed by the petitioner, by the respondents. Released after 3 weeks. Mr. Chalia, you are appearing in the matter.
Hi. My lord, I am appearing.
This is 33.
Yes, my lord, I am appearing for people. My lord.
On the last occasion, we were given time to find affidavit and for 17/7. And but they have not filed any
My
affidavit.
lord, we have not received any instruction, my lord. 2 weeks
And
time
the
may
court
be given,
directed
my
them that that's very be hard on the basis of the records available.
What is the matter about?
Regarding
Huh?
regularization of servicemen,
Regularization of service.
let them find their affidavit, no? But short time will be given.
The respondents, by the earlier order dated 19/6/26, the respondents were permitted time to file their affidavit. This coordinate bench by this order dated 19/6/2026 permitted the respondents to file their affidavit, failing which the matter was to be heard on the basis of the materials available on record. So, the learned counsel appearing for the BTC.
Yes, my lord. Respondent number 2, 3, 8 and 10.
Respondents 2, 3,
2, 3, 8, 9 and 10.
8, 9 and 10. Renews a prayer for some further time that the instructions have not been received. They are considering the prayer made. and only for the ends of justice, whether 4 weeks' time is granted to file the respondents to file their affidavit. Subject, however, payment of cost is 3,000. The Gauhati High Court Legal Services Committee. Positive. The Legal Services Committee. Released after 11 days.
Obvious man.
Minor, they one of court directed to file affidavit minor and he's going to retirement on next year minor.
Lordship, we have received the affidavit, my lord. We'll be filing it tomorrow morning, my lord. During the course of the day. tomorrow.
Appears for the petitioner, Mr. A. Pugan for the respondent submits the affidavit will be filed tomorrow.
During the course of the day.
Today or tomorrow?
Tomorrow, during the course of the day.
Tomorrow. Voting matter be listed again after 3 weeks, enabling the petitioner also to file rejoinder affidavit to any such affidavit that will be filed by the respondents.
Lordship, item
Released after
37 is a similar matter. He is the petition. 37, similar matter.
Allow this matter to be completed first. Why are you in a hurry?
Well, he said it.
Yes,
37 also not filed.
but 37 similar.
Similar. Deeply obliged.
Both the matter partial instruction has received and now it is under the office of inspector of school. Where he is examining the matter.
Not from the month of March, not my expected friends or somebody appears before this secondary taking time. Milord, in fact, these matters, if my learned friend agrees, can be disposed of by the Milord common order, Milord, which has been. And Milord, the issue is very Milord limited. We were receiving grade pay of rupees 8,700 Milord. Now, basing on a judgment delivered by this honorable court, Milord, in a writ appeal which is no way connected with us, we were not even the parties. They have suddenly taken up a decision, Milord, to reduce our pay, Milord, grade pay from 8,700 to 6,800. Now, Milord,
Which order you want?
Milord, the order, my lord, may be pleased to find in Pankaj Goswami, Milord, it is in the last page. At order dated 23/5/25. In another petition, my lordship has already gone through. It starts at page 153, Milord.
153.
My lord. The operative part is from 157. My lord, admittedly, in these cases, my lord, what has happened? District-wise petition were filed, my lord, and this is a case pertaining to Morrigaon district, my lord. When the case we filed, the my lord, department took a decision to keep the order impugned, similar to this petition, my lord, in abeyance. Now, my lord, when the impugned order was
Well,
kept,
this is with regard to area salary.
no, my lord, not area, my lord, regarding grade pay. What has happened, my lord? Our
160.
No, my lord, that is the part one of the direction has been issued, my lord. But my lord, the issue is regarding reduction of grade pay from 8,700 to 6,800, my lord. Now, this reduced pay has been directed to be paid as an arrear also, my lord, in addition to the final relief, my lord. Because, my lord, the finance department's notification, they have also
What has
violated.
happened to the
My lord.
petitioner's hearing after this order?
My lord, after this order, they are getting this, my lord, grade pay of rupees 8,700, my lord, in Morrigaon district. Now, my lord, this is the petition of Lakhimpur district, my lord.
Bring it on record, this
They
statement
regarding, my lord, the receiving of pay, my lord. Yes, my lord.
pursuant to this order.
Pursuant to this order, my lord, not these petitioners, my lord, the Morrigaon district petitioners are receiving.
This order
My lord,
at page 157, 157.
my lord.
was in the writ petition filed by petitioners from which district?
From Morigao district.
Exactly.
Yes.
So after this order, you are saying that they have
They
received.
are receiving. Yes, I can make. My lord, then another matter is fixed on coming Monday, my lord, next Monday. So, my lord, oh, my lord, then they have been directed to file affidavit. I will also file and rejoin them, my lord, additional.
Mr. Air Learned, Learned, Crown Senior Counsel, assisted by MS. S. Plus. And Mr. U. Sharma. State. State has renewed its prayer for filing further time, completion of instructions and filing necessary evidence. And Mr. Yeah, on the other end, is referred to the order dated
23/5.
20.
23/5/2020.
23/5/2025, part in WPC 2676 of 25, whereby the similarly situated persons like the writ petitioners from the Morigao district had approached this court, and this court by the said order had disposed of the matter, issuing certain directions to the respondents. Stop. Mr. Mia submits that pursuant to the directions issued by the court, those petitioners from the Morigao district have been receiving their grade pay at the rate of rupees 8700. Stop. The prayers of the present writ petitioner being similar, Mr. Mia submits that he also be permitted to bring on record the said fact by way of additional pleadings. Prayer made is granted. We released this matter again after 3 weeks. 2 weeks. 2 weeks.
Well, 3 weeks may be granted as the report from the inspector of Gauhati.
All right, 3 weeks. 3 weeks. 3 weeks.
The next item is also.
Which item?
36. Same, my lord, regarding Gauhati district, my lord.
Same order.
Same order. Obliged.
Matter and also yesterday, the respondent party has filed an affidavit in opposition. Sometimes one.
Counsel for the petitioner submits that the respondents have filed their affidavit yesterday. He has submitted that they would like to file their rejoinder to the said affidavit, raised for 3 weeks' time. Prayer made is allowed, released. After 3 weeks, interim order, if any, will continue in the next date of listing. Release this matter on 21st of August.
Yes. Your Lordship, matter pertains to monthly family pension and gratuity. Notices have been issued on 29/10/2025, but till date, no affidavit has been filed by the respondents.
My lord, we cannot receive any instruction. And kindly 2 weeks time may be granted.
Prayer for further extension of time is made by the council, appearing for the PTC authorities. Learned council prays for 3 weeks further time. Considering the issues involved, prayer made is allowed. Released again after 3 weeks. MS.
Pita Lugdar.
Pita Lugdar appears for the writ petition.
And it fix any date.
21st of August.
Lordship, the matter may be fixed at 2, Lordship. Council is in another court.
Your Lordship, instruction also not received, Your Lordship. Instruction is.
Let the instructions come. The State Council representing the Education Department renews a prayer for further time. 3 weeks further time is granted to complete the instructions and file necessary affidavit. Release taken after 3 weeks, Mr.
D. Bhattacharya on behalf of D. Pukas. D. Bhattacharya.
E. Bhattacharya appears on for the petitioner, Mr. N. Sharma for
Or as per number 5.
respondent number 5. Yes.
Deeply oppressed.
Yes.
Yes, my lord. I am the respondent number 4, my lord. The week's time may be allowed, I will find, my lord, the affidavit.
None appears for the petitioner. Mr.
Why Sikdar?
Y. Sikdar appears for respondent number 4. He prays for 2 weeks' time to file, complete his instructions and file necessary affidavit. Similar prayer is also made on behalf of the council appearing for the secondary education, MS P. Das was also permitted. Is also permitted 2 weeks' time to complete her instructions and file affidavit. Released again after 2 weeks.
Released to transfer matter because of election matter. Nobody has filed any affidavit till date matter.
And who is to file the affidavit?
Education, elementary education matter. This file matter.
Yes, elementary education.
Here we have not filed our application.
Do you propose to file? You have not received instruction.
My lord.
Mr. P.K. Bora, Planning Council, secondary.
Elementary.
Elementary education. Praise for and is granted 3 weeks for the time to complete instruction and file necessary affidavit. Mr. S. Star appears for writ petitioner, then Ms. S. Kataki appears for CI. Released again after 3 weeks.
Interim order passed.
Faster giving continue. Mr. S. Nath for
Item 50, what happened, my lord? I was transferred in his place. Interim order granted in his petition. I was not allowed to join his school. I have challenged this order dated 15th because the ground in which he has challenged this writ petition is my same ground. Because I did not complete 3 years service and Sribhumi is my home. But I could not join on 17th of March, I have been released. Now I am hanging, my lord, due to this stay order. I was not allowed to join.
have you filed a vacating petition?
My lord, I have implemented a deed petition I have filed because this transfer order itself is bad on the ground which is there.
Whose transfer order?
My transfer.
Transfer order whereby both of you are transferred out.
He has been transferred at Lanka. I have been transferred from Kachar district to this place. Now, because the Sribhumi district is my home district, his home district is Lanka. So he has approached the general lordship granted the stay. And the another aspect is that election commission guidelines says it has to be completed. I did not complete 3 years. But since I have been released, so I went to join there. But he did not hand over the charge. Stay order. I could not got the deed. And salary also I am not getting. I'm in a bad situation again. Someone has, another has been allowed to.
You have to file application for vacating. You have not filed.
Writ petition because the transfer order itself is, my lord, the in violation of the EC again.
Then we'll examine it.
My lord, that is what I am saying, my lord, I am not getting salary. The last order, my lord, was
What last order?
last day order, my lord, on the order dated, my lord, 10/6.
That is not the last order.
10/6 is the previous order.
Nothing else.
The salary to the salary aspect to the.
Nothing is there.
My lord, the previous order on. Salary aspect required to be considered.
See, if you want to refer to an order, please look into the order and make a reference. What is
My
the
lord,
last order? Last order.
My lord,
Which order?
My lord,
Release this matter again.
My lord,
WPC so and so.
My lord, on
After
10,
3 weeks.
10/6/2026.
N6 does not refer to anything.
And because of the such situation, my lord, my lord,
No,
my
release
page 40,
again.
page
After
40.
In my case, interim order may continue by.
Interim order wherever passed will continue.
My lord,
We are fixing a date.
my
List it on 21st
my lord, I'm not getting
August.
on RD. Kindly, because I am not getting the salary
We'll examine that.
on RD. Kindly,
No,
not 21st, my lord, I have some.
say that. You'll have it on 19th.
19.
Right.
Let's, okay.
Yes.
Oh, no, lot
Have
of
you
them
filed
also-
affidavits?
No, your lordship.
Yes.
Lordship, filed a common promotion order list published on 11/3/2026. I was a junior incumbent was selected
File to
as a administrator of my school year. Lordship. Which is reflected in Annexure 6 at page number 46. Lordship.
Page 46.
Yes, Lordship.
Yes.
My name is reflected as serial number 24, Lordship.
Then
And the respondent number 4 name has been
serial,
selected.
serial 24 in page number 46.
Yes, Lordship. And the respondent number 4, the name of the respondent number has been selected as page number 47 under reserve category, Lordship. Yes.
Yeah. Under SC.
SC category, Lordship.
Serial number 2.
Yes, Lordship.
Okay. Then
Lordship, I am holding as a post administrator since 2001, Lordship.
what is your prayer?
My prayer is to Lordship to set aside this.
Why do you want it to be set aside? You're posted as a regular headmaster. You want this order to be set aside?
Lordship, there is an exception in my case, Lordship. In all the schools in Assam, Lordship, the senior most incumbent, Lordship, has been retained in their respective schools, Lordship. I am the only one, Lordship, who has been ousted from my own school, and I have been posted in a different school. And I have only, Lordship, 16 years of service left, Lordship. This exception has been made, Lordship. And I am senior to the respondent number 4, Lordship, not senior, Lordship.
Is it contrary to the, is it not conceived of in the rules?
Lordship, they have to disclose the posting norms, Lordship, how they have posted the teachers, Lordship.
What about respondent 4?
Respondent number
Lordship, in our instruction, your lordship, they are praising only speaking order only. Your lordship, why she was not, your lordship accepted, your lordship. Your lordship, as per the
This
speaking,
is
speaking order.
It is not only in respect of your case. Come to serial number 2. The person who is transferred to a different school. Serial number 4. Sorry, serial number 5.
Lordship is referring to
Page 46.
24. Serial number 24. Bonita Dr.
But Lordship, in most of the schools, Lordship, the senior most incumbents have been retained.
No, you see, that's what we are trying to point out. No? You come to serial number 2.
Kalyan Janata High School,
Uh,
place of posting, Mohanting.
then number 4, sorry, number 5, then number 7, number 10,
Serial number 15.
number 12,
Also. Serial number 2.
13. So it is not that you have been picked up and adverse orders have been passed.
And Lordship, the respondent number 4, she being a candidate from scheduled caste, Lordship, she has already superseded many candidates, Lordship. Now she cannot get a double benefit, Lordship.
What double benefit?
Lordship, she has already superseded many, Lordship, the general candidates.
You belong to OBC.
OBC.
Lordship.
She has not taken over OBC post. You can't get into SC post.
Serial number 2 under SC category.
Lordship, I am the senior most incumbent in my school, Lordship.
That's right. But you tell us that the rules are there to say that senior most has to be retained in the same school.
That is why, Lordship, what is the posting now? They have to file an application.
You show us from the rules that there is no provision. Posting norms is a different issue. But you have to tell us that the rules categorically lay down that senior most to be retained in the same school. Is this the mandate of the rules? Perhaps not. Rules do not say so specifically.
But Lordship has seen some exceptions are there, but in almost most of the school, Lordship, the senior most have been retained.
Yes,
I'm going to
state,
request Lordship-
give us your instructions why you have
Our
transferred.
return will be, your lordship, as same, your lordship, while passing the speaking order.
We
Yeah.
want to know why you are passing a speaking order if the grievance of the petitioner is serial number 24 is the senior most. Right? So where was the need to send her to a different school and retain the next senior most at SC category? What was the rationale? The Mr. S.K. Das appears for the petitioner. MSP Das appears for secondary education. Mr. Hussain for respondent number 4. MS Das will obtain instructions as to the criteria applied in respect of the incumbents were shown to be promoted to the post of regular headmaster. The criteria applied in respect of the regularly promoted headmaster in respect of their postings against the existing vacant posts in the schools. Stop. Petitioner is agreed that she, being the senior most teacher at DCB Girls High School, she being the senior most assistant teacher in DCB Girls High School, she was posted in EM Tholajan High School. There is private respondent who is an SC category, is an SC candidate, has been retained in the same school as regular headmaster. Let these instructions be placed before the court in 3 weeks, released again after 3 weeks.
I'm deeply obliged.
I appear in item 46 and 47 and 6. In these cases, the petitioners before proceed are selected candidate teachers in B and LP schools. Their certificates were terminated on the ground that some excess appointments were made. Now, while the selected candidates have been identified, the petitioners before lordship, they are also in the select list, wherein this select list has been held to valid violation of code in connected cases.
Only in this case, my lord, director has called for the report from the DEO, my lord, whether they are similar or not. Let the matter may come after 4 months.
Does it require that much of time to go through whether this order is similar or not?
No, my lord, petitioner are the fence-sitters, my lord. The other petitioner has approached this honorable court in the year 2020.
No, fence-sitters is a different issue.
My lord.
Said the doctrine of the applicability of calling them fence-sitters will apply only when the order is similar. But first you have to get your instructions whether this order is similar or not. So why do you need 4 weeks? You go through the order, tell us whether it is similar or not similar.
As per my instructions.
Why the instructions of the inspector is required?
Because, my lord, we have to verify, my lord, their appointment, my lord, whether they are genuine or not, my lord.
Selectors is there in the reflection.
For that, my lord, DEO is the my lord appropriate authority. Therefore, my lord, director has called for a detailed report from the DEO.
As per my instruction, my lord, the district authority has sent the instruction to the my lord, director. District authority has sent on which side? The director perhaps my lord, the holding the.
No, my lord, on 22/7/2026, my lord, I have received the instruction, my lord. We are waiting for the report.
For the instruction of the RTI, my lord. Said by the district authority. You have not filed your affidavit also.
Received the instruction.
Mr. Rai Sokia appears for the petitioner, MSS Sachia appears for the state respondent, the secondary, elementary. Mr.
Yeah, in item number 6, PTC is the rate of the party, respondent number.
Right, we'll pass separate orders then. In item 6, this is in respect of items number 45 to 47. The respondents submit that their instructions are awaited. These instructions relate to the information as to whether the status of the petitioners are similar with regard to the petitioners in WPC number 5641 of 2020, which came to be disposed of on 2/12/2025. So the Senate Council submits that the appointments of the petitioners will have to be verified by the department, and only then they would be in a position to say whether the present writ petitioners are similarly situated like the writ petitioners in WPC so and so. In view of the prayers made, release this matter again after 3 weeks. Matter be listed on 24th of August. We will decide that on 24th. Insofar as item 6, heard counsel for parties issued notice returnable 4 weeks. Mr. Rai Sokia for the petitioner, MSS City about the elementary education, and Mr. Atria for respondent number 4. And for the state, Mr. S. Sharma appearing for the respondent number 5. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. Released again. This matter along with item number 45 to 47, number get a deal. Yes.
Yes. Probably 49 is not similar matter, Lordship.
Item number 48.
49 is wrongly take with this case.
Yes. 49, 5 to.
But I don't appeal for. Acha, you appeal for.
49 is different.
Yes, sir. There are 2 other writ petition pending, 1424 and 1425.
It is submitted that.
Milords, may I just point out? May I just submit, Milord, before my learned friends make a submission? Milords, how?
49 with regard to
Just 1 minute,
Yes,
sir.
yes.
Please bear with me. Because how they are submitting 49 is different. I do not know if your lordships have your lordship's order of 11th March 26 in item 49. The same issue is being urged by me in item 48.
Shri so-and-so Learned Senior Counsel for the petitioner urged 3 grounds. It is contended that section 120.
You're referring to which order?
Lordship, this is order dated 11th of March 26.
In which writ petition?
In petition at item 49, that is petition number 1422 of 26.
Eleventh of March, yes.
Lordships have that order, my lords?
Yes.
The petition, my apology. The petitioner is aggrieved by a demand come show cause dated so and so, which has culminated into an order dated so and so. Shri so and so Learned Senior Counsel for the petitioner has urged primarily 3 grounds in support of his challenge. It is contended that 122(1)(a), which has been applied, was inserted with effect from 1, your lordship, that is 10. Actually, it should be 10, not 1. 21. Whereas the period in question is from 1819 to 2122. The same issue I am urging and I am submitting before your lordships.
You are appearing in this item.
Item 48, my lords.
You are not appearing in 49.
I am not appearing in 49.
How does it matter to you?
No, my lords. I am just submitting that the submission that this is different is not correct.
It's for us to consider.
Lordship,
We'll see that. If they don't want to press this matter before this court, it's for them to decide.
That
Whether this matter has been heard.
No, I was, as an officer of this court, I was just pointing out to your lordships that the same issue is being urged in both the petitions.
What do you say, Mr. Bora? Mr. KL?
Inference, submission of the petitioner in item number 49, the issue involved in 48 and 49 are different. And there are 2 writ petition matter is
No, you go through this order and tell us whether it is separate or different. 49.
49.
This order is available. Is it not available with you?
No. Earlier, some other counsel was appearing in this case.
No, this order is there. Do you have a copy of that order? Please
No,
share it
I'll
with
give-
Mr.
I'll give it to
KL.
Mr. In this case, lordship, in item 48, the matter relating to single notice for multiple years. Probably this issue is not involved in the item number 48.
Please, may I just submit? Both the issues are the same. One issue is whether 122(1)(a), they have a jurisdiction to invoke.
All right, for the time being, we'll hear 48. 49 we'll decide later. It is submitted by the council appearing for the parties in item 49 that this matter is not similar to item 48. Therefore, this matter should not be tagged along with WPC 5671. Accordingly, registry will separately list WPC 1422 of 2026.
Along with item petition or 1424 and 1424.
Along with WPC 14, it is submitted that there are 2 other writ petitions which may be listed along with the same matter, which is WPC
1424 and
1424
and 1425.
1425, both of 2026.
Required and lordship another 4 weeks time to file a warrant.
4 weeks further time is granted to the respondents to file their affidavit. These matters. Yes. Interim prayer, if any, will continue. Yes. MS so-and-so appears for respondent number 1. Yes. On behalf of SK Many. Yes. Yes. Yes, you're Mr.
Lordship, Bharat Raichand.
There was some other matter which was heard by a coordinate bench.
Yes.
Which the respondents say that the issues raised are covered.
Judge, may I just make a submission, Lords?
Yes.
I had argued both those matters, Lords. Therefore, as an officer of this court, I'll make a submission, Lords. This is not covered by those judgments.
I'm making a statement as an officer of this court. It is not covered by those judgments, my lords. The facts are completely different. I'll satisfy your lordships, my lords. I will present both those decisions for your lordship's consideration. But, my lords, before that, I must point out, my lords, two things. My lords, I have a threefold submission. I have a threefold contention.
We'll fix it for hearing.
Lordship may place it on the same day, my lords. I have no difficulty, my lords.
Good. Same day?
On my lords, any day, subject to my learned friend's convenience, any day. I'll just briefly tell you, lordship, there are three principal contentions being raised.
Yes.
And the issue, my lords, whether they can issue a consolidated notice and an order for more than one financial year. My lords, that issue is at large before the apex court. The apex court has granted interim stay because it was pointed out to the Honorable Supreme Court. I'm making this, I'll just show that also. The Bombay High Court, my lords, held in favor of the SSC. The Madras High Court held in favor of the SSC.
Delhi High Court went against.
I'll tell you, lordship. The Telangana High Court, the Andhra Pradesh High Court, the Kerala High Court, all held in favor of the SSC. The single judge of the Karnataka High Court, my lords, a single judge of the Karnataka High Court followed those line of decisions and held in favor of the SSC. The revenue filed a writ appeal, intra-court appeal before the division bench. The division bench, following the Delhi High Court judgment, my lords, reversed the single judge's order, my lords. Against that is the order, my lords, where we have gone to the apex court. And it was pointed out to the apex court, my lords, that high courts are taking contrary view. And my lords, yesterday, I must tell your lordships, this is the order passed. Matter is fixed on 24th, that is Friday. My lords, yesterday, identical matter was listed before the Honorable the Chief Justice of India, my lords. The Honorable the Chief Justice of India has fixed all these matters, my lords, because against those judgments which were in favor of the SSC, revenue is also before the apex court. There are only two contrary views, my lords, Karnataka and Delhi. Parties are in before the Supreme Court. The Honorable the Chief Justice has fixed all those matters before the bench headed by Honorable my Lord Justice Narasimha. There is a direction that order has been dictated yesterday. That also I'll circulate for your lordships, and a special bench will hear those matters.
So these are fixed on 24th.
This matter is fixed on 24th. The matter which was before the Honorable the Chief Justice, he has directed that all these matters should be heard by the bench headed by Honorable Lord Justice Narasimha. That order also I just place it before your lordship's consideration. Lordship, therefore, may I pray, my lords, any date convenient to your lordships, my lord?
This particular order, of course, doesn't show that there is some interim order suspending the order.
For interim stay.
There's a notice.
Yes, my lords. Yes, my lords.
But the order has not been stayed.
No, my lords. That will be listed on 24th. We'll come to know, my lords, on 20th. The notice for stay, my lords.
No, notice for stay and a stay of the judgment. There has to be
your lordships are right. Your lordships.
There's a notice on stay.
Absolutely right. Notice for stay because your lordships, they were apprised that conflicting views are being taken by the high courts.
All right.
Lordships.
Yes, Mr. KL.
I place the judgment of single bench of coordinate bench.
No, first give us the clear position of what is going on in the apex court in respect of these matters.
Lordship, against the judgment of single judge, data bill was preferred by division bench. That has been upheld by this bench. Data bill number 230 of 2026 on Monday. That judgment has been passed, probably that has been uploaded.
No.
Yes.
Read appeal.
I am submitting.
Appeal in respect of which matter?
Passed by the Lordship coordinating the Tata project.
Okay.
That is been challenged before division bench. Division bench has passed.
You place it before the court.
Lordship WPC number 2230 of 2026.
WPC number
230 of 2026. Judgment was passed on Monday, 20th of item number 17 was.
What is the writ appeal number?
Writ appeal number 230 of 2026.
In the matter where I appeared, we have also filed a writ appeal before the Honorable Division Bench. That is pending, my lords. I am not aware of this judgment, but I'll take a look, my lords, if it is so.
Yes, Lordship. This
yes. Certainly, no. If he's making a submission, probably this issue must not have been pointed out before the division bench, that the matter is at large before the apex court, and apex court is considering this issue.
Lordship knows when there is no specific stay order. and the judgment passed by this honorable court will prevail.
I'm not making that submission. I'm saying why duplicate? If they decide once such a law for the land, I'm not saying any duplication, my lords. In fact, my lords, the Bombay High Court has referred this issue to the larger bench, and the larger bench is kept pending for the decision of the apex court, my lords. Because since the apex court is seized of the matter, I'm not making any submission that your lordships cannot decide. No, my lords. My learned friend should not misconstrue my submission, my lords. नहीं कर ले क्या नंबर है इस पे क्या है
Matter has been delegated to the department.
Yes, Lord.
The issue has not been decided.
Yes, Lord. See, one issue has been decided regarding multiple notice that has been decided as single judge that there is no jurisdictional error. That is an appeal regarding other issues that has been relegated to April 4th.
Third counsel for the parties, Mr. Bharat Raichandani appears for the writ petitioner, and Mr. S.C.K.L., senior counsel, appears for the union. The what authority? GST.
GST.
GST. And MS so and so appears for Union of India. It's submitted by Mr. Chandani, Rai Chandani, that there's a similar matter which is pending before the apex court, which is directed to be listed on 24th of July, being SLB numbers 22321 of 2026. Stop. It is a copy of the order passed on 9/7/26 by the apex court is placed before the court. It's further submitted that there are several other matters, cross appeals filed either by the union or by the SSC, which are pending before the apex court, and there is a direction by the Chief Justice of India that these matters will be heard by a bench comprising of Justice Narasimha, presided by Justice Narasimha. Stop. The learned counsel submits that he will place a copy of this order. Stop. Mr. KL, on the other end, submits that coordinate bench had already decided the issues in these matters, and by judgment and order dated 8/6/2026, passed in WPC 2922 of 25. Stop. These matters were appealed against, came up in appeal before the division bench of this court. In writ appeal number 230 of 2026, by order dated 2007/2026, the findings of the coordinate bench was upheld. Stop. Mr. KL therefore submits that the issues raised in the present petition can also be decided in terms of the order passed by the coordinate bench, which is upheld by the appellate court. The parties will apprise the court as to the status of the proceedings before the apex court on the next date fixed, and the parties will also examine whether the counsel for the petitioner will also examine and apprise the court whether these issues stand covered by the judgment and order dated so and so, passed in WPC so and so, which came to be upheld in writ appeal number so and so. Release this matter on 13th August.
May I just pray for some Friday, my lords, my apology.
Fridays.
Some Friday, my lords.
I thought you'd be busy on a Friday or a Monday.
Mondays, my lords, Mondays.
You want it on a Friday.
Can it be 21st, my lords?
All right, 21st.
Subject to you.
21st August.
Great. We're obliged. Great. Obliged. We are obliged. Great.
Matter pertains to non-renewal of the termination order of the petitioner who has been terminated. In fact,
This is the, my lord, foundation of our case. Commissioner Secretary to the Government of Assam Higher Education Department. Kindly see, my lord, the copy is marked to Vice Chancellor, Gauhati University, Dibrugarh University, Cotton University, Krishnakanta Pandikoi, State Open University, KKB, Ancient, etc., 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 Assam Science and Technology. Implementation of government decision taken by Cabinet in its meeting held on 19/9/12, raising retirement age. I am directed to convey the government's decision taken in the Cabinet's meeting held on 19/9/12 as stated below for taking necessary action at your end. It was decided to raise the age of retirement of all professors of educational institutions, including medical colleges, to 65 years. So I'm reading the last sentence once again, my lord. It was decided to raise the retirement age of all professors of educational institutions, including medical colleges, to 65 years. Now, my lord, please come to page 20, my lord.
Yes.
By this order, that is 8/9/23 order, in pursuance of UGC Regulation 18, notified by dated so and so, and on the recommendation of the selection committee, Executive Council of the Cotton University, in 31st meeting held on 28/8/23, accepted and approved the promotion of the following academic staff under Career Advancement Scheme by resolution number so and so. Rakhi Kolita Moral, present designation Associate Professor, Department English, so and so. Kindly see designation after promotion, Professor, and date of effect 25/5/23. So, my lord, by virtue of the fact that the petitioner was promoted as a professor, so, my lord, she claims that her services should continue up to the age of 65 years. Now, my lord, will kindly come to page number 25. This is a communication by the Secretary, Higher Education Department to the petitioner, my lord. Subject is regarding extension of service to 65 years. With reference to the above subject cited above, I am directed to request you to submit the proposal through proper channel of the department for further necessary action in this regard. Lord, will kindly come to page number 38. This is a part of the, my lord, proceedings of the Executive Council of the Cotton University. Kindly see on the top, action taken by Government of Assam. In 19 September 2012, Assam Cabinet took a decision
to raise the retirement age of the professor, and the same was communicated by Higher Education Department to all educational institutions by letter dated so and so for taking necessary action. In the later, government decision taken in the cabinet meeting was communicated, mentioning as follows. It was decided to raise the age of retirement of all professors of education institutions, including medical colleges, to 65 years. It may be worth mentioning that based on the aforesaid communication regarding the cabinet decision of 19 September 2012, Cotton University appointed a professor through direct recruitment at chemistry department at the age of 61 years on 24 November 21, who is still working in the university. So, my lord, based on the decision of the government of Assam as communicated on 19/9/12, one professor in the chemistry department whose age was 61 years as on the date.
Somebody else.
Somebody else. Now, my lord will kindly come to.
So this is to show that beyond 60 also there are people being
are working. Yes. Now, my lord will kindly come to the next one. This action taken by the Cotton University. In view of the aforesaid communication dated 26th of September, the Executive Council of the University took the following resolution to raise retirement age of the professor at Cotton University. Agenda item number 14, discussion on implementation of the Assam government decision taken by Cabinet of Government of Assam in its meeting held on 19/9/12, raising retirement age of professors communicated to all vice chancellors as mentioned by the Higher Education Department by letter dated so the 26th of September. Now, eventually at page 39, Lordship will find the Executive Council adopts this decision. EC accepted the implementation of raising the retirement age of all professors of the university, communicated to all vice chancellors as mentioned by the Higher Education Department by letter dated so. The meeting of the Executive Council to adopt the execute the decision of the Assam Cabinet to raise the retirement age of all professors of Patna University, including those in the special cadre as covered. We are in fact covered by this, my lord, 52, 51, 50. Actually, my lord, those who belong to, my lord, erstwhile Cotton College and Cotton College State University, they are a special cadre, my lord. And after formation of the Cotton University, whosoever is appointed, they are all governed by, my lord, the same set of rules and regulations. Anyway, this has got some relevance. I'll come little later. Now, my lord, the decision was taken by the Cotton University pursuant to this communication of 26th of September, and the resolution of 3/8 was forwarded to the, my lord, government. Kindly see B. The resolution of the EC held on 3rd August 22, taken by so was communicated by Registrar Cotton University to Commissioner and Secretary to the Government of Assam Higher Education Department by letter dated so. In response to the letter of the Registrar of the Cotton University, Higher Education Department government by its letter responded the aforesaid letter in the following term. There is no cabinet decision to raise the retirement age of professor of education institution. The decision is restricted to medical colleges. So this is a very peculiar stand taken by the government that there is no decision to raise the age of retirement of professors in other institutions other than medical. Whereas, my lord, if your lordship would kindly come to page 38 for a moment, that portion is quoted, my lord. It was decided to raise the age of retirement of all professors of educational institutions, including medical colleges, to 65 years. Anyway, my lord, in the meantime, please come to page 40. There was another professor who was given the benefit of this, my lord, in the Department of Physics. Please come to, my lord, page 40 in the middle, the subpara starting with, in the meanwhile, Professor Ganesh Chandra Wari, Department of Physics, Cotton University, has written a letter dated 21st of February 23, to the Commissioner and Secretary to the Government of Assam, stating that since he has been already promoted to the position of Professor in Physics under CS promotion on 16th of 16/1/18, he is scheduled to be superannuated in 24th of March. As per the norms, his age of retirement should be raised to 65 years from 60 years, as per government's later dated sense. In response to the aforesaid petition of Professor Wadi, dated 21st of February 23, Secretary to the Government of Assam Higher Education by Department dated so stated that in pursuance of decision taken by the Honorable Cabinet held on 1990, Government of Assam in the higher education is pleased to extend the service of Ganesh Wadi, retired Professor Physics, to 65 years. So, my lord, that gentleman in the chemistry department and this gentleman, Mr. Ganesh Chandra Wadi, they were given the benefit. Now, what they did, my lord, what the Government of Assam did, which are impugned in this present proceeding, my lord. So, page 43. This is the order in respect of Ganesh Chandra Wadi, my lord, whereby his age of retirement was extended up to 65 years. Because he was supposed to retire on 31/3/24 and he was given from 1st of April 24. Now, my lord, will kindly come to the impugned order at page 62. Exactly impugned order. Now, the stand of the Cotton University as well as my lord state is now drifting from each other. With reference to the subject and letter cited above, I am directed to request you to appoint any professor within the approved post of professors by following due process, and Professor Ganesh Wadi may also be accommodated accordingly if the university so desires. Now, possibly what Government of Assam wants to say is, Miller, since Cotton is an university, is an autonomous body. Therefore, if you would like to follow the UGC regulation of 18 and the promotion policy known as CAS, Career Advancement Scheme, you may do so. But we are not responsible for the payment and all. End of the day, my lord, whether it be a staff who joined Cotton College or who earlier joined Cotton State University, and the persons who were appointed post creation of the Cotton University, every money, each and every pie goes from the Government of Assam. Only thing is, Milord, as per the statute, the pensionary part would be looked after by the Director of Higher Education. Whether it is by, Milord, part of the main budget, whether it is by way of a supplementary grant, whether it is by way of a contingency fund.
No, by this order, you are putting this to challenge.
Exactly. Because, my lord,
Page
a
62.
stand is sought to be taken. Now, my lord, Lordship knows, once cabinet takes a decision, it is binding on all the departments. Lordship knows this Suprabhat Steel and all these cases. Where it says, my lord, once cabinet takes a decision, then it is binding on all. And as far as the execution part is concerned, it was considered to be a ministerial act. Now, once there is a policy which is holding the field, whether Higher Education Department, Government of Assam or Cotton University can take a stand against that. That's the question. Now, let us see, Milord, from the affidavit, what is the stand of the Cotton University. If a lordship, they would
No, what is the import of this page 62?
The purport of this order at page 62 is, we are not going to do anything. Mr. Cotton University, if you want to appoint somebody to it, you are the master of your own cause. Regarding salary and all, don't trouble us. That is what they explained in the affidavit that I have to place. There are two affidavits, my lord. One filed on possibly 23/4/25, other on 9/5. When did it? 9/5 how I
Yes, 23.
Yes. Please come to Milord, page number 64. It starts. Please come to paragraph, page 67, para 6. Before that, I think I'll have to place this part, Milord. Page 67, top. The extract of the cabinet decision as received from political cabinet cell department was forwarded to the universities for necessary action in their end, which includes consideration by respective decision-making bodies of the universities, because salary of the university faculty are paid from university fund, not from state executive. For all state government employees, retirement age in general is 60 years until expressly notified otherwise by respective administrative department, as has been done in the case of engineering colleges. However, as stated above, there is no such notification for extension beyond 60 years in respect of the permanent employees of higher education department drawing salary from the state executive through treasury. It may be mentioned herein that there is no post of professor in any non-technical colleges under the higher education department, government of Assam. Lord will kindly take note of this. I'll come to this little later. This is absolutely wrong. Post of professor is there under the 1982 Assam Education Service Rule. Para 6. That the deponent begs to state that since the erstwhile Cotton College faculty formed a special cadre with respect to their service conditions at the time of their appointment, that is as per section 52(2) of the Cotton University Act, their retirement age would remain unchanged at 60 years. The same university registrar, my lord, vice chancellor, who has taken that executive council decision, is now saying all these things.
Oh.
Now,
this is filed by the
respondent number 3, my lord.
Secretary, respondent 2.
No, it is by 2.
Yes, secretary.
I'm so sorry. This was on secretary. However, universities can appoint engaged faculties, including professor, as per terms and conditions of the respective universities from their own fund. In case of Cotton University, there are 27 posts of professors, which can be filled up by the university authority by following due procedure as provided in the Cotton University Act and the other relevant regulations. The salary remuneration for these categories of employees of the university shall be borne by the university from their own fund. It mentioned here is that Government of Assam provides grants in aid to Cotton College every year, Cotton University every year. However, the faculties and other employees engaged by Cotton University cannot draw salary from the state executive through treasury. At the end of the day, whether it is granting aid to the university or providing for salaries of education under the heading of Milord teacher's salary, these are all part of the budget. It is coming from the one, my lord, executive, that is state of Assam, consolidated fund of the state. Well, by writing 2-3 sentences, my lord, position does not alter. The deponent begs to state that in view of the above factual position, if Cotton University wants to elevate any of the faculty of the erstwhile Cotton College to the position of professor, they may do so following due procedure, provided after elevation, the faculties shall be shifted to the university cadre, drawing salary from the university fund to the GIM. So, my lord, the stand of the government of Assam is twofold. First, they are disowning the cabinet decision, which they cannot. Number one. Number two, they are saying, my lord, that if you promote anybody by following the due procedure established by law, you may do so, but you will have to change him from the present system of salary payment. You'll have to put him in the university cadre, and where their salary would be met from the grants in aid, which is being given to the government of Assam. These are the two stands of the Milord state government. Now, please come to the other affidavit. It starts at page 73. It is filed by Cotton University and the Vice Chancellor, 3 and 4. My lord will kindly come to page number 75.
I'll read from the fourth line from the top. The matters of service, including service conditions like retirement of the teachers and staff of the Artswell Cotton College, are decided and directed by Government of Assam. The Cotton University and its authority are merely the executing authorities in respect of the directions so given. It is the internal administrative and academic affairs and activities of the universities that are carried out by the respondent number 3 university. The decision and direction of the Government of Assam, insofar as employees of the Artswell Cotton College are concerned, are binding on the employees as well as Cotton University. On the other hand, the employee recruited by the Cotton University and Artswell Cotton College State University are governed by Act State as statutes, rules, and regulations of the university. B. Salary of the employees of the Artswell Cotton College are paid by Government of Assam to its treasury, while salary of the employee of the Cotton University, including Artswell Cotton College State University, are paid out of Cotton University Fund. That means, my lord, what they are trying to say is the salaries of Artswell Cotton College, like the petitioner, their salary would be paid by the Government of Assam through treasury, while salaries of employees of the Cotton College, including Artswell Cotton State University, would be paid out of the fund of the Cotton University Fund.
So now there is only Cotton State University.
Now there is Cotton, not even state, Cotton University.
Cotton University.
First, my lord, it was Cotton College, then Cotton State University. Now it is Cotton University.
Now, are there two sets of cadres? That one who were earlier working in Cotton College?
Yes, my lord, there is some distinction is there. That is there, my lord, that I'll place. Let me place the facts. I'll come to them. Two more paragraphs, my lord.
Yes.
Then my lord will kindly come to page 76E.
Yes.
The petitioner was serving in the Cotton College as an employee of Government of Assam when Cotton University Act of 2017 came into force. She continued to be a government servant and her service conditions continued to be governed by service rule applicable to the employees of the Government of Assam, including fundamental rules. That means they are trying to say, Lord, as a government servant, FR 56 determines. So for earlier it was 56, 58, 59, and eventually 60. So therefore they say, Milord, and now Cotton University is taking a U-turn. Cotton University had adopted through the Executive Council, they have adopted that decision, Milord, whereby 19/9/2012 Cabinet decision was approved. My lord, let me make one more point very clear, Milord, that Cabinet, pursuant to the Cabinet decision, an executive order was passed in the form of that order, whereby it was communicated. It never remained as a Cabinet decision in papers. As we all know, my lord, after every decision, there has to be an administrative order in the name of the government. So, my lord, that is the order by which it was communicated. Now, these are the, my lord, factual position. Now, my lord, we have filed a reply where I'll just place two things, my lord. That affidavit starts at page 87. Please come to page 91. Sorry, page number 90. This is the reply affidavit. Please come to the last four sentences. Thereafter, by acting upon the Cabinet decision taken on 19/9/12, the service of one Professor Ganesh Chandra was extended up to 65 years with effect from 1/4/24 by order dated 16/7/24. However, later on, the order dated 16/7/24 was withdrawn by assigning reasons that Professor Wari was not drawing salary from the university fund. Now, as far as the gentleman, Milord, Professor Wari is concerned, while there was a, Milord, a confusion regarding his status, he has been appointed as a vice chancellor of a state university Therefore, whether it is in Cotton College or otherwise, he will enjoy his salary at the higher level up to 65 years. So he also filed a litigation. Perhaps now he would not like to face it, because as a vice chancellor, in any case, his services will continue up to 65 years. Now, this is important because as per section 23 of the Cotton University Act, the Executive Council, amongst others, is the competent authority in these matters. A perusal of the Cotton University Act would reveal that Executive Council has been provided with various powers, from holding, controlling, and administering the property and funds of the university, preparing statements regarding annual financial requirement, to appointment of officers, teachers, technical staff, and other employees of the university, and define their duties and conditions of service. Section 12 of the Cotton University Act provides for appointment of Vice Chancellor. As per Section 12(3), the Vice Chancellor shall be whole-time officer of the university, and Section 13(1) provides that Vice Chancellor shall be the principal executive and academic officer of the university. Section 16(1) of the Act, the registrar is defined as a whole-time salaried officer of the university, and he shall be appointed by the Executive Council. Section 17 of the Act prescribes the powers and duties of the registrar. Section 17(1) provides that registrar is the custodian of records, common seal, and such other property of the university as the Executive Council shall commit to discharge and to manage such property. Apparently, the registrar works under the directives of the Executive Committee, as such being an authority prescribed under Act of 2017. The resolution adopted by the Executive Committee in its meeting dated 3/8/22, that is page 38 of the petition, my lord, is binding upon the officials of Cotton University, including registrar of the university. However, a perusal of the affidavit in opposition filed by the respondent number 3 and 4 would go to show that the stand taken in the said affidavit is not in conformity with the resolution of the Executive Committee pertaining to extension of service of professor up to 65 years of stage. Further, the respondent number 2 in his affidavit in opposition has categorically stated that Cotton University is at liberty to appoint the petitioner as professor of the university within the approved number of the vacant post of professor, that is 27 in number, by following the procedure if the university so desire. Apparently, there exists no legal or procedural impediment preventing Cotton University in allowing the petitioner who continue to serve till 65 years. So, my lord, by way of this affidavit in reply, we have tried to deal with the stand taken by Cotton University as well as the state. Now, my lord, what we find from the affidavit of the state and Cotton University are threefold basically. State government would like to say, my lord, first, that there is no policy, which is not correct. There is a policy. Secondly, they would like to say that if the Cotton University desires, they can promote somebody under CS, but will not provide the money. How can that be done? Cannot approve it and reprove it. And as far as Cotton University is concerned, Miller, the Executive Council, which is the highest authority, having taken a decision, Miller, the registrar or the vice chancellor, they cannot resign from. They are bound to, these are all binding on them. That is what is indicated in section 23, 12, 13, 16, and 17. Now, let me place the, my lord, statute of the university. My lord will kindly have this. Second, you. My lord, I am referring to the Cotton University Act first. My lord will kindly come to section 12(3). The vice chancellor shall be a whole-time officer of the university who shall hold office for a period of 5 years and shall be eligible for reappointment. Then, my lord, will kindly come to section 13(1). The vice chancellor shall be the principal executive and academic officer of the university and shall, in the absence of chancellor, preside over. Actually, my lord, he is the principal executive officer. Then, my lord, will kindly come to 16(1). The registrar shall be a whole-time salaried officer of the university and shall be appointed by executive council on such terms and conditions and remunerations as described. Then, my lord, will kindly come to section 17(1). Powers and duties of the registrar shall be following: to be custodian of records, common seal, such as other property of the university as executive council shall commit to discharge and to manage such. Then, my lord, these are the positions. Then kindly come to, my lord, section 23. Following shall be the authorities of university. So amongst others, my lord, serial number 2 is the executive council, who had adopted the resolution to, my lord, adopt the government of Assam decision. Then, my lord, will kindly come to section 28, powers of the executive council. Please come to 28(6). Subject to the provisions of this act and the statute, it shall appoint officers other than the vice chancellor and chancellor and vice chancellor, teachers, office, technical staff, and other employees of the university, and define their duties and conditions of service, and shall provide for filling up of the temporary vacancies. So, my lord, executive council at page 38 of the writ petition, having adopted a resolution to accept the retirement age of, my lord, professor as 65 years, my lord, their affidavit, the, my lord, university or the vice chancellor would not have taken a contrary stand. That is why I have referred to this. Then, my lord, will kindly come to section 52 regarding this cadre. Please come to, my lord, section 52. Existing teachers and staff. All posts of Cotton College and Cotton College State University, including the vacant posts, are transferred immediately to Cotton University with effect from the date of commencement of this act. The existing teachers and staff of the Cotton College and Cotton State University shall constitute a special cadre with respect to their service condition at the time of their appointment. That means, my lord, all the existing staff of the Cotton College and the transitory phase, there was a phase when Cotton College State University existed, they will constitute a special cadre, and with respect to their service conditions, my lord, though the language is not very appropriate, perhaps what is sought to be conveyed is that whatever condition of service was obtaining on the date of their appointment, that will govern them. Perhaps that is what is sought to be conveyed, though the language is. Now, my lord, 3 is important. All pension matters of the present and past teachers and staff of the Cotton College, now upgraded to Cotton University, shall be handled by Director of Higher Education. So, my lord, one thing is very clear: whether the erstwhile employee of Cotton College or Cotton College State University or Cotton College University, my lord, which came into being post 2017 Act, the pension matters will be dealt with by the Director of Higher Education. So it has got nothing to do with the government, by the Director to handle. So as far as, my lord, existing employee of the Cotton College and State University, they are all transferred to the university. Therefore, my lord, this stand of the government, what will kindly appreciate. Now they say in the affidavit, they wrongly say, they speak of, my lord, only Cotton College, and in the other bracket they are trying to keep, my lord, Cotton College State University, Cotton University. I think that stand of the secretary in the affidavit is wrong. I think what they wanted to say is that as far as erstwhile employees of Cotton College and Cotton State University is concerned, that will be paid by the treasury. And as far as emoluments and the remuneration of university employees and faculties are concerned, it will be provided in the budget in the form of grant in it. But I pose a question to myself, what is the difference between the in any case, both the money will come out of the consolidated fund of the state.
University's employees obviously will not be government servants.
Naturally.
So therefore, their pay and everything will be taken up by through the university.
Yes.
Irrespective of the sources of funding.
Now, assuming, my lord, there is a distinction and there is a requirement of recognizing the distinction, then also, my lord, their stand is not correct, because under the Assam Education Service rule, professor post is there. They say it is not there. And they have the rules, my lord. Assam Education Service rules, 1982. Assam Education Service Rule 1982.
Yes.
698. Yes. Milord will kindly come to page 699. Class and cadre. The service shall consist of the following. Now, class 1, Milord, director, additional director, principal, principal of science college, principal of state institute of education, joint director, so and so, so and so, so and so, so and so. Then Milord will kindly come to Roman 12 at page 700. Vice principal and professor of government degree colleges. So, within class 1, Milord, professor was a post in respect of government degree colleges. So, she was a Milord, petitioner was an employee of Hartsville College. She got her, earned her promotion. She, of course, attained her, Milord, 60 years on 30th of June, 1924. Oh, sorry, 31st of October, Milord, I'm sorry. 31st of October, 2024. So then we approached this Honorable Court, Milord, and this Honorable Court, by order dated 30/10/24, was pleased to pass an order of status quo, which is continuing, and I am also serving as on. And Milord, since I was not paid my salary, on last occasion, Milord, there was an order passed by this Honorable Court that until these issues are decided, at least I should be treated as a contractual employee and should be paid by my salary. So, Milord, the first point taken in the state government's affidavit that there was no post of professor in the Cotton College is not correct. It's wrong. And second logic, Milord, regarding payment of salary, with all respect, I'll submit, Milord, I could not find any distinction.
Regarding
Yes.
salary.
Salary. They say, as far as Cotton University, Hartsville Cotton College at State University, the salary will be paid. Yes. Section 52(2) recognizes that they are a separate class, though their services.
What is your specific prayer in the writ petition?
My writ petition is, Milord, I should be allowed to serve till the age of 65 years. That's my only prayer. Nothing else. And by virtue of the interim order, I am continuing. But I have not been paid my salary till then. Neither have been paid any provisional pension, nothing. So, Milord, the first point that there is no post of professor is not correct, as has been clearly demonstrated, Milord. And secondly, Milord,
Cotton College is not there anymore.
No, it's Cotton University. So therefore, Milord, their argument is not at all tenable. Now, Milord, they have also taken this stand that this order is applicable only to medical colleges and not to other colleges. That stand they cannot take, because A cabinet decision is binding on all the departments of the government. Education, higher education department cannot take a decision against the cabinet. I'm placing one judgment on this point, you know. Leading case on this point is, my lord, that Ramjawa Kapoor's case is a very famous case, my lord. Relying on that, our High Court has decided this case, my lord. My lord, 2006 for GLT page 1. But I have not given the whole judgment. I have given the relevant paragraph 41. Page para 41. The cabinet, being a general controlling body, is constitutionally entrusted with the duty of formulating national policy whose decisions are binding on all governmental departments. The decisions so taken by the cabinet are bound to be implemented by each and every wing of the government. As it is not open to any individual department either to modify or act contrary to the decision so taken by the cabinet. Every department is bound by the collective decision taken by the cabinet. Cabinet is an integral one which functions through various departments. It is on the basis of the documents submitted and the result of discussion amongst its members, cabinet comes to a conclusion. Thereafter, the decision is carried out by all departments. The department concerned is required to issue appropriate notification in order to effectuate the policy decision so taken by the cabinet, even if it involves drafting of a legislation or framing of a rules as the case may be. Issuance of a notification in exercise of statutory function in order to give effect to a broad policy decision of the cabinet are considered to be ministerial act, which I pointed out. It would be futile to contend that policy decision taken by the cabinet would remain dead letter unless the concerned department moves in the matter and issues notification implementing the decision. The argument, if accepted, may result in disastrous consequence and may cut at the very system of constitutional governance which we have given unto ourselves. Citizens cannot be made a scapegoat in the crossfire between the interdepartmental feuds or deadlock. Implied recognition of the stated principles. Now, Lordship knows.
When was the cabinet decision taken?
2012. September 2012. That Lordships will find. Please come to the revert back to the writ petition, my lord, at page 23. Yes. September 2012. It was conveyed, my lord, but the decision is of 19. Anyway, my lord, this is the order by which, my lord, this is the order ministerial act and the main decision is of the cabinet. I am directed to convey the government's decision taken in the cabinet meeting held on 19/9/12 as stated below for taking necessary action at your end. It was decided to raise retirement age of, kindly mark the word, of all professors of educational institutions, including medical colleges, to 65 years. It was not the decision of the cabinet to increase the age of retirement of doctors and professors only of medical colleges. It says of all professors of educational institutions. It is not an inclusive, my lord, it is a very exhaustive definition. If there is any doubt also, my lord, that doubt has been set at rest. Now, my lord, this is binding on each and every department. Today, the higher education department cannot take a stand that these decisions should be confined to professors in medical colleges. End of the day, my lord, government is
No,
supposed
is that the only bone of contention?
That is the only bone of contention.
That it is only for medical college?
And that's what the affidavit says.
Or is it a case that this decision will be binding on professors of, let us say, government colleges and government institutions?
No, it will, according to us, it's not, let us give a literal meaning to the whole thing. It was decided to, why this copy was marked to Cotton University? Why it was marked to Dibrugarh University? Why it was marked to Gauhati University? If it was to be, confined to only medical colleges?
We want to understand.
Yes.
That insofar as Cotton University is concerned, there was cadres. One is Cotton College earlier, as the employees are there. And the other is
Cotton State University.
Cotton State or Cotton University.
Then eventually Cotton University.
Cotton University. Now, we don't know what the respondents will say. Is it their case, or what they're trying to say is that this 65 years will be applicable only to the government college?
No, that is not their stand. No, their stand is it is applicable only to medical, not to others. And two, they say that you are a separate cadre, your salary is being paid from the treasury, and university salary is being paid from the Grand Senior. These are the two grounds. So, my lord, my humble submission is, and the government has said also, I have placed that letter, if the Cotton University wants to implement it, let them implement it. But will not pay the salary from, they will not get the salary from the treasury, they will have to get the salary from the Grand Senior. Well, I am least bothered from where the salary comes. I want that my rights should be ventilated, vindicated. Lordship knows, in Suprabhat Steel, the question which arose was, State of Bihar took an industrial policy resolution to give the benefit of, my lord, exemption from sales tax. Now, my lord, it was denied. Then, my lord, doctrine of promissory estoppel was sought to be invoked. Then, my lord, the state took a stand that yes, the cabinet has taken a decision, fine, but finance ministry is yet to take a call on it and issue the relevant exemption notification. There the Supreme Court says, sorry, your stand cannot be accepted, because once cabinet takes a decision to give exemption, then it is binding on the finance department. As far as the finance department's role is concerned of issuing a relevant exemption notification, it is a ministerial act. So same is the case here, Miller. Cabinet has taken a decision, therefore all department across the board of Government of Assam is bound to take a decision on this. So, Miller, now the matter is very clear, Miller. As far as the stand of the Government of Assam is concerned, that there is no post of professor in the Cotton College is not correct. It is there. Second, the stand of the government is there are two cadres. One cadre covered by 52(2), and other is, my lord, the employees of the university. As far as the university employees are concerned, they will be paid from out of the Grand Sine, and as far as the erstwhile employees are concerned, they will be paid from the, my lord, through treasury. And thirdly, they say if the Cotton University wants to give, they can give. I'll just place that later, my lord. Lordship should kindly take this affidavit, my lord, at page number 672. Yes. Please come to page 68, my lord, para 7. Para 7, page 68. The deponent begs to state that in view of the above factual position, if Cotton University wants to elevate any of the faculty of the erstwhile Cotton College to the position of professor, they may do so following due procedure, provided after elevation, the faculty shall be shifted to the university cadre, drawing salary from the Cotton University Fund through GIA mode, that is grants in aid. Now, my lord, only thing that state will have to do in case of salary of the petitioner, instead of treasury, it will be brought to GIA mode. A very simple thing. Well, is it a justification for a responsible state government to take such a stand? Money is coming from consolidated fund of the state. That to say that one will go through a treasury mode, one will go through, ultimately all salary will come out of the treasury. It's not that in Cotton College there is a milord. Nowadays every salary is being paid milord the bank account. It's only a ministerial act. So therefore my humble submission is milord, it's a very unreasonable stand. You have taken a policy, you should implement it. Now I as a professor milord, I otherwise milord by one. Otherwise, I would have retired on 31st of October 2024. Now, I approached the Honorable Court on 30th itself, and there was a status quo order by virtue of that I am not continuing. And in fact, my lord, I am discharging all duties. But till then, I have not been paid my salary from the month of November 2024. In last occasion, there was an order issued by the authority, my lord. So, authority, my lord, to release the salary. Now, just one more thing, my lord, along with the statute, I also gave a copy of the, my lord, Cotton's first statute. So, lordship will have that for a moment. Uh, 45. Same thing, my lord, it is in the statute, therefore I thought I must place it. Existing teachers and staff wide section 52. The existing teaching and non-teaching staff of Cotton College and Cotton State University shall constitute a special cadre with respect to their service condition at the time of their appointment. This is, my lord, at verbatim, my lord, this is 52.2. Now kindly come to 45.3. The teaching and non-teaching staff of erstwhile Cotton College and Cotton College State University forming a special cadre shall be entitled to all benefits of teaching and non-teaching staff of the Cotton University, including career advancement scheme of UGC and seniority in similar position to be maintained by the competent authority. This shall also apply to the existing non-teaching employees. If I am entitled to CS promotion as an existing employee, my lord, then why not my age of retirement and my salary? So, my lord, the stand I understand, my lord, the stand of the Cotton University, they are under pressure, my lord. They have no way but to resist our claim. But I am very sorry to say about the stand of the government of Assam. You are a welfare state. You yourself have taken a policy decision. You yourself have promoted that gentleman in the chemistry department who was 61 on the date, and you gave him the benefit of 65 years. You have given the benefit to Professor Wari, who was given the benefit. Then, of course, my lord, since he was made, my lord, a vice chancellor, in any case, he will continue up to 65 years. Now it is my turn, my lord, and there are so many in the line. So, therefore, my humble submission is, lordship will issue a simple direction to the state government and the Cotton University to honor the cabinet decision, and my lord, I should be allowed to serve till the age of 65 years, and I should get my all pecuniary benefits. That's my case.
Yes.
So, lordship, the point of contention here apparently boils down to whether it is 65 years or 60 years for the employees who were then working under the then Cotton College. Now, lordship has the act with lordship. It has been provided by the senior. If lordship comes to section 52, that is the very basis of this entire issue. 52.1
All posts of Cotton College and Cotton College State University, including the vacant posts, are transferred immediately to Cotton University with effect from the date of commencement of this act. Then 2, the existing teachers and staff of Cotton College and Cotton College State University shall constitute a special cadre with respect to their service conditions at the time of their appointment. That is, at the time of their appointment, the employees of the then Cotton College, they were government employees. They are governed, or they were governed by the Assam Education Service Rules, 1982, which Anand Senior has written, and as well as all the other conditions of service of a government servant. So they continue to be governed by them, by those conditions. Then 3, it's clarificative.
They will continue to be governed till when?
Till they retire. And of course, the after retirement is subsection 3, which says all pension matters of the present and past teachers and staff of Cotton College, now upgraded to Cotton University, shall be handled by the Directorate of Higher Education. Not CCSU, only Cotton College. Because why this? Because they were government servants, or they still are government servants, those were still servants. That is the reason why their salaries are paid directly by the government, because salary is one of the components which determines the master-servant relationship. Therefore, my lord, the salary, that is the stand taken, that the salaries are paid through the state exchequer, through the treasury, not like the employees of Cotton University. That is the difference. So the statutes which had been relied on by Millen Senior, section statute 45.3. 45.1 is similar, my lord. It's rather the same. It relied on 45.3. It says the teaching and non-teaching staff of erstwhile Cotton College and Cotton College State University forming the special cadre shall be entitled to all the benefits of teaching and non-teaching staff of Cotton University, including career advancements. Reason is simple, my lord. Because they are serving in the same institutions, the same benefits would apply to them as far as what we can give. That is, we are not discriminating between employees of the then Cotton College who are in the special cadre and employees of the university directly recruited. They are entitled to CAS, which we will give. Now, the petitioner here was given CAS promotion. That has been agreed to by the government by issuing the pay slip. The CAS promotion resolution was forwarded to the government. That is not on record. Of course, I have my instructions. That has been given to the government. The government pays the salaries to her as professor, meaning thereby they approve. So she continued as a professor. The problem here arose because of this 2012 cabinet resolution. The cabinet resolution, the wording there is, it includes all education institutions, including medical colleges. Later on, it has been sought to be projected as though it is only of medical colleges. Of course, I am not on that. That is for the state. But it remained that one of the addressees of that notification or circular was Cotton College State University then. Accordingly, we had taken a resolution in the Executive Council raising the retirement age of professors of the university to 65 years. We have done. But of course, in the resolution, anyway, it is 65 years for employees. Now, I understand there is a heartburn.
There is a
heartburn because the erstwhile Cotton College teachers who are now professors.
Who are now?
Professors. Since they are government servant, as per FR 56, they have to retire at the age of 60. Whereas the employees directly recruited, or the professors directly recruited and promotee professors of the university, they retire at 65.
Why?
Because the Executive Council had taken a resolution that they will retire at 65 because they are directly our employees. The erstwhile Cotton College employees, they are government servants.
The decision of the cabinet was taken on which date?
26/9/2012. 2012.
When did Cotton University come?
2017. So
therefore, When the cabinet has taken a decision in 2012, stating that the retirement age shall be 65 professors, unless there are materials to suggest that it's restricted to technical or medical institution. It is binding on all educational institutions, more particularly government education institutions.
Why not? But the universities, since they are autonomous.
But you had given them the protection.
No, the state government employees who are working in the university,
including professors.
My lord, there are two sets. One are the professors who are directly recruited by the
We are not
university.
on that. The professors who are there in Cotton College, lecturers, assistant professors, associate professors, they're employees of Cotton College.
Yes.
On a given date, prior to their services being brought under the university, they are governed by this.
Yes, ma'am. Yes,
makes them a government servant.
My lord, yes. My lord is right.
You have given them the protection under the university that it shall be a special grade.
Yes.
Special cadre.
Special cadre.
And directly recruited to the university is another cadre.
It's a separate cadre.
Now, this special cadre ordinarily they would retire at the age of 60.
60. Yes.
But for the decision taken by the cabinet.
Yes, ma'am.
That
my lord,
it shall be increased to the age of 65.
My lord, that is what I am on. That is for the government, not for the university to decide. Because they are government employees. Now there was a submission made the affidavit as well that there was no professor in Cotton College. That is factually incorrect. As has been
there was no.
That is factually incorrect.
What is incorrect?
That there was no professor in Cotton College. That is factually incorrect, as has been rightly pointed out on behalf of the petitioners. The rules say so, and I also have yesterday they could find out one document of 1992, wherein in Cotton College, some persons had been promoted as professors. This is just for lordships. This is just to apprise them. This is not on record. 92.
This is just to supplement your submission that the post of professor is available.
Is available.
No
and therefore, caste promotions were made. We had recommended them. The government paid the salaries. Now, the problem here is of the 2012 cabinet decision. His lordship has said that, rightly said so, that since they were government employees, as on 2017, to the 2012 decisions should apply to them. However, my lord, their coordinate bench of this honorable court has held that that particular cabinet decision is not enforceable. And I'll place that. Be that as it may, would I be permitted to make a proposition? Because of this hard, we also have to run the university. Because of this hard burn, whether they'll retire at 60 or 65. They're entitled to caste promotion according to us. They're entitled. There's no doubt. Of course, at the moment, the caste promotions are on hold. There are some discussions.
But there is no caste promotion here.
The issue is not caste promotion. So what the proposition which I would like to is, if the government takes a call on this, insofar as their employees are concerned.
That's not a proposition for you to make. That's for the government to take a call on this.
Yes. If this matter could be
if you can impress upon the government to take a call, we'll be more than happy.
Lordship, that is not for us because they are their employees.
So therefore, let us hear the government.
Yes.
But as far as you are concerned, you agree that there are two categories.
There are two categories. They are the special cadre.
Special cadre.
And they are governed by the government rules. So therefore,
and if there is
if the government decides that they retire at 60, it is up to them. We have no role to play there. And Your Honor, the other decision, two decisions which, one of course, if we would be on arguing the matter, but if this proposition is taken up, and if the matter is sent to the government to decide whether it could be given to 65 or not, that other decision may not be so relevant. But this particular decision, Your Lordship, I had taken the liberty to highlight if that is not a problem.
Absolutely not.
And this is a decision of the Oh, sorry. Anyway, it coordinate venture, right? WBC 3782 of 2024. Judgment dated, order dated 19/3/2025. This was on there was a person claiming that he has to retire at 65 since he is a principal. Here, if my lord comes to it, the decision discussed Article 166, Pachitter Singh, Bansal and all. And if my lord comes to para 15 of the judgment at internal page 7, in the present case, the cabinet decision on 19/9/2012 approving the retirement, raising the age of professors from 60 years to 65 years has not been converted or crystallized into an order issued by the state government under Article 166. Thus, when there is no government order implementing the cabinet decision, the same cannot be said to be enforceable in law, inasmuch as the state cabinet decision can only be said to be provisional in nature, which can be changed by the Council of Ministers on reconsideration of the matter. Para 17, it is also settled law that the question of increase or reduction of the age of superannuation of any government employee rests with the concerned state government in terms of its state policies.
No, but this is on
a different one, but
this is on the issue that once a decision is taken, it's required to be implemented by taking the formalities, etc.
Under Article 166, it has to be taken. So the observation of the coordinate bench is this cabinet decision is not enforceable. Be that as it may, what I would be on is if the government decides this matter so that we can run the university smoothly. So I understand there is a hard cut.
What is the Supreme Court judgment?
Supreme Court judgment is on the proposition, my lord, that there can be more than one retirement age. This is the citation is 2023 SCC online, SC 1074. 2023 SCC online, SC 1074. Prakasan MP versus State of Kerala. Here, SC 107. Para 11, 17, and 19.
Yes.
Para 11. It is well settled that the age of retirement is purely a policy matter that lies within the domain of the state government. It is not for the courts to prescribe a different age of retirement from the ones applicable to government employees under the relevant service rules and regulations. Nor can the court insist that once the state has taken a decision to issue similar government order that would extend the age of retirement of staff teaching in homeopathic colleges, as was issued in respect of different categories of teaching staff belonging to dental stream and the Ayurvedic stream, the said government order ought to have been made retrospective. Then Lordship may skip the next sentence. These are all matters of policy that engage the state government. It may even elect to give the benefit of extension of the age to a particular class of government employees while denying the same benefit to others for valid consideration that may include financial implications, administrative considerations, exigencies of service, etc. Lordship, it will Prakasan homeopathic or Ayurvedic doctors. Then Lordship may come to para 17 that on the proposition that there is no vested right.
Is this for what proposition?
That there can be two sets of retirement ages.
How is it relevant here?
Why not? Because in Cotton University, one set.
See, the question is, you may extend, you may consider this to be another contract employment or whatever employment under the university and continue until the age of 65.
Why not? For that, we'll have to appoint her afresh.
You appoint her?
No, for
this
that
is one issue. For which there has to be a determination what is the retirement age.
Exactly. So for that determination, if it is left to the government to with a direction
but in view of the coordinate bench order, it is already settled.
It is settled that there is no decision.
There is no appeal against this.
So therefore,
there's a division bench judgment.
No, single bench.
This is single bench.
Oh no, this is a private college. Can you see the facts? Paragraph 2.
And my
provincial
lord,
SPs.
here a right was sought to be asserted. We are not seeking any right to be asserted. We say there is a decision implemented. That's there is a difference between asking for a mandamus and my lord asking for a mandamus in the present case. There, my lord, they were saying that I should get the benefit of 65. I said, we are not saying that. We are saying government has already taken a call. Please implement in our case.
My lord, in this decision, the facts relied on the cabinet decision itself, which is being relied on by the petitioner. That decision has been held to be non-enforceable. So therefore, what I would be on, my lord, is if this matter is relegated to the government, let them decide on this within a time frame if lordship directs. That would be in the best interest of everyone, because it is not that we don't want her. And insofar as fresh appointment is concerned, under UGC, she has to come through a selection process, but she has to retire. That retirement age is for the government. And
it has to be decided with the government. Why come to the court?
No, because of the heartburn. That is because in the same institution, there are two sets of persons. One who would retire at 65, one who retires at 60. Because of that, that is what I would do.
So the heartburn, it's caused by, it's an artificial heartburn created by the university and the government.
If the government
if you are concerned about the heartburns, then obviate the heartburns by giving them extension of their services till 65.
Why not? That the government has to extend.
How can the government?
Not,
if the government is of the view that no, this 65 is not applicable to this set, then they superannuate at 60. In which case, it will be left to the university to decide how to initiate or how to regulate their appointments.
My lord, for that they'll have to come through a regular selection process, because under UGC we cannot simply appoint them. They have to come through the selection process under the UGC guidelines.
Yes, government. We'll come back to you, Mr. Nair.
Lordship.
Is it 60 or 65?
Manoj, for government employee, Manoj, Assam government employee, it's 60 years, Manoj.
No, professors.
The professor, in fact, professors also, if the age of 65 for professor is in universities, Manoj, not in colleges, Manoj. And as far as the concern,
so was the cabinet memorandum.
Can you see page 24, Manoj, of the repetition? This letter has been issued to all the universities, Manoj. Not the colleges, Manoj.
Because this is issued to universities because the colleges are under the university.
And
there are hundreds and thousands of colleges. This is the policy decision to be conveyed to the university so that it filters down to the affiliating colleges.
Our stand is clear, Manoj.
This is a very ridiculous submission you are making, that because it is addressed to universities, it is bound for university. You show us the cabinet memorandum. Cabinet decision, cabinet memorandum, where is it? Call for it. Call for it. Call for it. We'd like to see the cabinet proposal, which is placed before the cabinet to decide for what purpose the proposal was noted.
Then I'll be giving some time.
Yes. But from the, do you disown this communication at page 23, 24?
No, our stand is that, Malad, the cabinet decision was taken with respect to Malad, medical colleges and engineering colleges, Malad. Because in engineering colleges,
what basis are you giving this stand? Because then you'll have to disown this 23 and 24 to say that these letters issued by Commissioner and Secretary Higher Education Department has wrongly informed the decision of the government.
I'll be relying upon the same judgment.
Judgment will come later on. First, clear the facts. You come to page 23, 24. This is issued by the commissioner.
Commission.
So are you saying that the commissioner conveyed a wrong information?
So, my lord, thereafter the department has to issue notice, my lord, notification individually.
You first
The
show us
higher
the,
education department that
first
issue
show us the cabinet decision. First show us the cabinet decision.
but for that, my lord, for I may be given some time, or my lord, as my learned senior sir has given a proposal, my lord, to send the matter to government and decide on that.
Mr.
No, my lord, that we
Chaudhary?
don't. Lord, if you also kindly give me 5 minutes time. My learned friend from university they have already taken a decision to implement this decision. Let us be very, page 39. So therefore, now to take a U-turn is not fair. Number one. Number two, my lord, my learned friend is saying that we belong to a different cadre. Very well, we belong to a different cadre. But nevertheless, we are entitled to CS promotion. I have been given a CS promotion only. And if I have given, my lord, equity knows no halfways. If I am entitled to CS promotion, then I am also entitled to the age of retirement up to 65 years.
So
Not the
CS promotion is under the
career under the UGC guidelines.
UGC guidelines.
So, my lord, under UGC guidelines, the professor is directly appointed. And through another mode, under the CS, a person can be under the same UGC guidelines, one can be promoted. So, my promotion was not by way of any state government exercise. Exercise of powers by the state government, but CAS is a Millard scheme under the UGC guidelines only, 2018. But the judgment which has been referred to by my learned friend, where it was said it is not enforceable, Millard, I have not read it, but I can explain the position very clearly, Millard. Number one, the cabinet decision is taken under FR 56A. Let us be very clear about one thing. Even without 56A also, cabinet has the power. But nevertheless, my lord, FR 56A empowers state government to determine the age of retirement. Yes, as a other than professor, my lord, age of retirement is 60 years. There is no dispute. But the moment one assumes the office of a professor, then as per the government of Assam's own decision, he is entitled to retire at the age of 65 years. Now, my lord, now my learned friend was referring to Bachitar Singh. My lord, Bachitar Singh is an authority for the proposition that merely because there is some note in the file, that by itself is not an order of the government. In order to be an order of the government in the meaning of Article 166, there has to be an administrative order. And at page 23, 26/9/2019 is an administrative order of the concerned department. That a decision has been taken. So therefore, they are writing to all the universities so that the affiliated colleges can be taken, cases of affiliated colleges can be taken care of. Now, I have placed the statute of the university, statute number 45, Millard. It says that employees of the Artsville Cotton College and Artsville Cotton State University, they are entitled to CS promotion, and CS promotion is under UGC regulation. So if somebody can be directly recruited, he can serve up to 65 years. A person who has earned CS promotion under the same UGC guidelines by virtue of promotion, why can't he, Millard, serve up to 65 years? It is not a case, Millard, there is dearth of any administrative order. So Bachitar Singh will not apply.
The university says that if the university recruits somebody in the cadre of a professor, that person will serve up to 65 years.
But I have been given promotion by the university, Millard.
I know, but CS, that does not alter your status as an employee under the government.
No, Millard, that's an additional safeguard given to us. Well, also have that statute for a moment, Millard. That statute 45. That makes the position absolutely clear.
$45.
45.3.
Yes.
The teaching and non-teaching staff of Artsville Cotton College and Cotton College State University forming the special cadre shall be entitled to all benefits of teaching and non-teaching staff of Cotton University. What does it mean, Mila? That means a teaching and non-teaching staff of Cotton University, as much benefit he or she enjoys, same will be enjoyed by a teaching and non-teaching staff of erstwhile Cotton College and Cotton State University, including career advancement scheme. So because under the career advancement scheme, I can travel up to 65 years, I need not be appointed. Is it so unintelligible, Milord, as the university would like to say? And they are being accepted, they are being adopted. I think they are stopped from arguing all these points. And Milord, that judgment which has been placed, where in a private college, Milord, that decision was sought to be implemented.
The finding of the court is that this is the decision of the, no decision has been taken place.
So, Milord, will kindly, lots of people see, Milord, it's
You examine the judgment.
On the face of it, my humble submission, Milord, this is per inferium. And moreover, Milord, the division bench judgment of the Ganapati roller mill was not placed before the bench, Milord, coordinate bench. Anyway, Milord, the cabinet memorandum be placed. Cabinet decision we have placed. Let the cabinet memorandum be placed. That will make the position be absolutely clear. What was the intendment?
Yes, Mr. Counsel.
Madam.
Heard Mr. K. Chaudhary, City Counsel, assisted by Mr. R. N. Dekka.
Yes, yes.
And Mr. S. Das appearing for the
Standing counsel
Department of Higher Education.
Madam.
And Mr. Nair, Senior Counsel, assisted by Mr. H. Brahman for the Cotton University. Mr. R. Moro for the Accountant General. Matter, the grievance of the writ petition is that notwithstanding the cabinet decision taken by the state enhancing the age of superannuation of professors from the age of 60 to the age of 65, state benefit has not been conferred. So, petitioner has attained the age of, crossed the age of 60 in the year 2025, October 25.
24, Milord.
24. And since the benefit of enhancement of age of superannuation was not granted, petitioner approached this court by virtue of an interim order issued passed by the court. Petitioner is presently rendering her services and the Cotton University, the Department of
English.
So, pleadings have been exchanged. Respondents, the state respondent by their affidavits submit that there is no decision taken for unilateral enhancement of the age of superannuation from the age of 60 to 65. Rather, it is restricted only to cases of medical colleges and other technical colleges. State of Assam. So, the council appearing for the Cotton University on the other end submits that the statute and the Act of Cotton University clearly provide for two separate cadres, one relating to the employees of the erstwhile Cotton College and the other
Cotton State University.
Cotton
State University.
Cotton College.
College is special.
Cotton College and subsequently by the and one cadre pertaining to Cotton University. So, learned senior counsel for the Cotton University submits that the decision to enhance the age of superannuation to 65 is a decision taken by the state or required to be taken by the state. If the state permits the enhancement of the age of superannuation, there is no difficulty for accepting the contentions of the council to the petitioner. But as on date, that enhancement has not been accepted by the state. So far as the university is concerned, if university is concerned, all appointments made to professors will be till the age of their superannuation age will be 65 years. However, if any appointment is to be made petitioner by the Cotton University now, it shall be a fresh appointment in terms of the UGC norms and guidelines. So, para considering the issues involved, the bone of contention is whether the state cabinet had indeed taken a decision to enhance the age of superannuation from 60 to 65.
In respect of professors of all educational institutions.
In respect of professors of all educational institutions. Or whether the decision is restricted only professors of medical or technical universities, technical education. Under such circumstances, the State Council is permitted to produce a copy of the Cabinet Memorandum and other related decisions that may have been taken by the state in this regard. The State Council is permitted 3 weeks time to complete his instructions. Release this matter again after 3 weeks.
For further hearing.
For further hearing.
Deep blue. Deep blue. Deep blue.
Wait, please, Your Lordship. Lordship, due to some personal difficulties, my senior, Mr. P. Mohanto, for respondent number 6, could not appear today. If Your Lordship may please to list the matter.
My lord,
after some day.
my lord, in this case, my lord, that my lord, the military department has filed their affidavit. My lord, the contention of the case.
Do you want to file a rejoinder?
No, my lord, no worry.
All right.
My lord, the fact hearing is that, my lord, that as part of my lord.
There is a prayer made for accommodation. What do you say?
Accommodation, my lord, for numerous occasions, my lord, they have been directed to file their affidavit. So their contention already, my lord.
Lordship, a short date will be very much helpful.
Otherwise, my lord, the petitioners, the other side.
It is submitted that the pleadings are exchanged in the petition. The petitioner does not wish to file any rejoinder affidavit. Matter we posted. We'll post it for hearing. We'll issue rule for the records. List the matter for hearing.
Here, one of the issues are very simple. Only the contention of the petitioner is the social science teacher, as part of section 3(1)(11).
Release this matter on 20 August for admission hearing.
Obliged. Lordship. Lordship, respondent number 2 filed their affidavit in opposition. I want to file reply, Lordship, sometime maybe.
Counsel for the petitioner submits that in response to the affidavit in opposition filed by the respondent number 2,
yes,
they would like to file the rejoinder affidavit. We praise for 3 weeks. 3 weeks time. We list this matter again after 3 weeks. Mr. P.K. Bora appears for the state. For the education department. Which education? Elementary. Yes. Readings are complete?
Yes.
It is submitted that readings in the matter are complete. Matter be listed for admission hearing on 20 August.
In this matter, I am appearing for secondary education.
LS P. Das appears for secondary education.
I'm deeply obliged.
Where is the any affidavit by the respondents?
Lordship, in this matter, we are awaiting our instruction. We are filing positively.
Mr. A. Fukan, counsel appearing for?
Under the elementary education.
Elementary education, praise for and is granted 3 weeks time to complete his instructions and file necessary affidavit. MS so-and-so appears for the petition. After 3 weeks on a date to be fixed by the registry.
Deeply.
Yes, please, Your Lordship. My lord, the respondent are required to file a fresh affidavit, Lordship.
By which order? Is there an order?
Yes, Lordship, as per last order also. They are required to file and order dated 9 to 20.
Yes, elementary education. Elementary education
If I can appear, my lord,
is permitted further 2 weeks' time to file their affidavit in the matter. Mr.
NH Board.
NH Board, VIPS for the written.